Actually, we have pray for a listing of an item on 21st.
Hmm?
On 21st of this.
21st.
Yes.
What motion matter?
No, admission.
Admission matter.
No, sir.
All right, 21st.
Public.
Wait, please, my lord. I beg to mention two writ petitions, and both were against the Assam Tourism Development Corporation, similar issue. And I have received the instruction to withdraw these two. So therefore, I pray for listing it tomorrow. Yes. Obliged.
For order, packet 2 and 3.
In one of the review, my lord, the order was passed by the Honorable Mr. Justice Michael Jathan.
There is some I also.
Yes,
Not I.
I have for deletion of M from the party respondent.
Whose name?
A comptroller and auditor general, lordship.
Why do you want to be deleted?
Lordship, because we have no role to play, lordship. And in the original application, writ petition also, we are not made party also, lordship.
Review.
Review for twice.
Nice.
Which order you want to review? Review of which order?
My lord. Order at page, my lord, 11, my lord.
11. Why do you want a review of this?
Order was in my favor, my lord.
Hmm.
Order was in my favor, but my lord, one thing that my lord, consequential benefits, that part, my lord, was not clarified. For which, my lord, the authority has not given the consequential benefits, my lord. That is why, my lord, a clarification was.
Show us you pointed to us which paragraphs.
Review, my lord. Paragraph 21, my lord, page 112. 23, my lord. Double presentation was. Double presentation was. 23. Hey. Michael order. Second. First two. Available. In terms of the recommendation of the CPC, fifth CPC, my lord, entry level pay scale was 5,000 to 8,000, my lord. And my lord, subsequent after completion of 5 years, it was required to be enhanced, my lord, to 5,500 to 9,000. And after 15 years, my lord, it was required to be enhanced.
Hey, case to same thing. More case to look same thing.
It's a case.
It's not a question decided. Huh? It's not
It's
decided.
one of us.
My lord, in this case, my lord, there is another review filed by me, my lord.
Item number
It
3.
was, order was for Honorable Justice, Justice Michael, my lord, item 3, my lord. My lord, in this case, my lord, this, we have paid some person, we have paid, my lord, those who are entitled, my lord.
This is against the same judgment.
Same judgment, my lord.
My lord, following this judgment, my lord, that judgment
Yes,
my lord, rendered by
Yes.
Mr. Justice Dotan Kumar. against which my friend is seeking review.
But this should go before the concerned bench.
Yes, my lord. Last time it was listed before a concerned bench, my lord, but the order.
But both are they both connected?
Yes, my lord.
Why?
Because of the first order, first case, my lord, the subsequent order was passed by Honorable Justice Michael, my lord.
Subsequent order was passed.
My lord,
By following judgment.
following the judgment.
So until and unless this judgment is reviewed,
Yes, ma'am.
it may not call for review of this judgment.
Yes.
Yes, that is,
Then
but only that part, my lord, so far, there is two part, my lord, one part they are entitled, one part not entitled. my lord.
we'll discuss your review petition. You go and file an appeal. Why review? What is the ground for review?
Perhaps, my lord, the petitioner can approach the honorable single judge also, my lord, by filing a writ petition, my lord.
That is up
My-
to you to
my-
decide, but we find no merits in the review. In your review,
Lordship may close the review petition, my lord, granting liberty to the petitioner.
no
my lord,
liberty
to
is
seek-
required.
To seek
No
appropriate
liberty is
remedy, my lord.
required. If there is a new cause of action, you go ahead. Why do you need a liberty?
Because in this order, my lord, the relief was,
Your writ petition was allowed.
yes, my lord.
You want something more.
Fine,
You want something more.
my lord.
And for that, you want the judgment to be reviewed. For the judgment to be reviewed, this judgment will have to be recalled, matter will have to be heard.
The only
But
thing,
that's besides the point. The issue is that there is no error apparent.
yes,
Then
lordship may close the review petition, my lord, granting liberty to the petitioner, my lord.
no liberty. Why should we even use the word term liberty here?
My lord, they will again, my lord, by seeking the
You
same.
file whatever, if there is a new cause of action, you file it. Can we give you, can a coordinate bench give a liberty over a matter where otherwise you don't have a liberty?
No, my lord, what happened, my lord, the relief, my lord, sought for in this review petition was, my lord, supposed to be given by the fifth CPC. My lord, the first entry pay scale was given by this honorable court, my
No,
lord.
no, we'll go absolutely by the order. Your writ petition is allowed, respondents are directed to grant the revised pay with effect from so and so date.
My lord. That is, my lord, entry level pay scale,
Ah,
entry level pay scale. But subsequent, my lord, it was hiked by the FCPC recommended for pay hike after completion of 5 years.
was
And
it an issue before this court?
it was, my lord, was in the writ petition.
Huh?
That was raised in the writ petition.
It is not recorded in the order.
In the order, my lord, not recorded.
Then you did not have urged it. You may not have urged
So,
it.
my lord, that is why, my lord, I am praying for a liberty, my lord, for urging that point, my lord.
No, we can't give you liberty then. You did not urge before the court. Show us from the order anywhere that you had urged this point, court did not record it.
In the order, my lord, it has not been rejected, my lord. But in the writ petition, it is there.
Where was it pleaded? And you say you have argued at length.
Page 64, my lord. Mhm.
64 of the review petition.
Yes, my lord, page 35. I'm sorry, my lord. Page 35. Paragraph 7, it starts from page 34. Paragraph 7 of the writ petition. I have next the writ petition also. The recommendation part, also you'll find at page 61. Matter fifth CPC, my lord. Entry level pay scale was 5,000 to 8,000. And after 5 years, it was 5,500 to 9,000. And after 15 years, it was 6,500 to 10,500.
And what does paragraph 30 of the judgment mean? Benefit is already granted. Page number 26.
This is, my lord, subsequent pay hikes is in respect of, my lord,
Court had granted revised pay at so and so with arrears with
Right.
effect from 1196
1
in terms of recommendation of fifth
CPC.
CPC. Then sixth CPC
Yes.
in the post of superintendent grade 2. Then
In between, my lord, some part petition, the petitioner, my lord, he has completed 15 years of service in between. So, my lord, he was eligible for the, my lord, subsequent pay hikes.
he was eligible for
The subsequent pay hikes, my lord, after completion of 15 years, my lord. In between, my lord, fifth CPC and sixth CPC, my lord, he completed 15 years of service.
Huh?
Nine. Now come to page 35. Your claims are specified at the end of the paragraph.
Yes, my lord.
So you have been granted which one?
My lord, the first one, my lord, 5,000 to 8,000,
8,000, fresh
Yes.
entry.
my lord.
And
The subsequent one, my lord, after completion of 5 years and 15 years, that has not been recorded in the judgment, my lord. I'm not saying that it has been denied, it does not record it, my lord.
when is the decision of 25/2/2009? Where is that decision?
Petition is next to 9, eh? Yes, my lord, at page 76, my lord.
It's reflected in page 17 also, no? Same letter.
Yes, my lord.
Huh?
Yes, my lord.
And where is the recommendation? 61.
Yes, my lord, 61. This pay scale was subsequently replaced, my lord.
Hmm?
Recommended pay scales, my lord, subsequently, my lord, replaced. Entry level pay scale was it was recommended, my lord, 1,600 to 2,660
Hmm.
in respect of BRO, my lord, it is applicable, my lord.
And then replaced to 5,000 to 8,000.
Yes, my lord. And my lord, after 5 years, my lord, it was 1640 to 2,900.
Hmm.
It was replaced to, my lord, 5,500 to 9,000. And after 15 years, my lord, 2,000 to 3,500.
Now they have released only 5,000 to 8,000.
Yes,
Yes, Mr. Mehdi. Who's representing?
For Lordship, I am representing. If I may just point out, Lordship, the petitioner herein is not in service. Firstly. Secondly, Lordship, after the judgment of the learned single judge,
Hmm.
the matter was carried in appeal by us. The appeal was dismissed. Similarly situated other persons, that is the other case, they had also approached this honorable court, and the order which was in consonance with the order passed in the writ petition here was passed. We approached the Supreme Court, as Supreme Court has upheld. Thereafter, we have paid we have paid the persons who are eligible to get the revised pay, Lordship. That of course will be in the next case, Lordship. And we found, Lordship, 61 persons who are eligible, and we have released their enhanced pay, Lordship. And insofar as the others who we say are not eligible, because in the other case, Lordship, there were 100 odd petitioners. For that, we have filed a review. For that, we have filed a review for correction of the order, Lordship. Now, if he is not to be found in that list of eligible candidates, Lordship, then perhaps his remedy would lie in a writ petition, Lordship.
Which candidate, which petition, the present review
No,
petition?
There are two cases today.
Huh.
The issues are same, Lordship. Firstly, Mr. C. Chandrakumar had approached this honorable court, and the learned single judge had passed an order in favor of Mr. C. Chandrakumar, against which we filed a writ appeal. Our writ appeal was dismissed. In the meantime, 100 odd other similarly situated persons had filed the second writ petition, that is Brij Bhuvan. Brij Bhuvan followed the judgment passed in C. Chandrakumar. And in Brij Bhuvan, we filed a SLP before the Supreme Court, which was again dismissed. Now, after that, we are required to make the payment. But in Brij Bhuvan, what has happened, although 100 odd petitioners were there, actually as per our records, only 61 were eligible to get that enhanced payment. Therefore, we have released that enhanced payment to 61, and for the remaining 87, Lordship, since the orders had just simply followed C. Chandrakumar, we needed a clarification. We have filed the review in the other case, Lordship. Now, if Mr. C. Chandrakumar has not got it, because the issue is the same.
No, let us first clear the technicalities.
Lordship.
This review petition, first item, is before this court.
Lordship.
It was passed by the court,
Yes, Lordship.
which is not presently available, therefore it has come to the
Yes,
judge
yes,
holding the roster.
yes.
So far as the second matter is concerned, this is an order passed by sitting judge of this court.
Yes, yes.
Therefore, in all fitness of things, the matter should be placed.
In fact, last time it had come in that court only,
So
Lordship.
we are not taking up the number 2 matter.
Lordship.
We are now dealing with the first matter. Because
Lordship.
from the submissions, I can, what has followed is that this second matter came to be disposed of on the basis of
In terms of this order.
this one.
Yes, Lordship.
It was dismissal is effective order.
So here, Lordship, since the issue has attained finality now, because Lordship may be taking up item number 1, but the issue in both the cases is the same. Therefore, the Brij Bhuvan case has followed the judgment and order passed by the learned single judge in this case, Lordship. Now, we have released the payments. His name does not figure in that list of eligible person,
You're talking about this number one.
number one.
Itu পাইছে?
Is it?
Why is it not
This
eligible?
is a list.
এখন-
And
এখন বেলেগ সেইটো কিছু লিষ্ট না সেইটো বেলেগ ফেয়াৰ কি পাইছে বেনিফিট ইন 94 আপডেট হৈছে
Why is the name not eligible?
oh, Lordship, I think I have mixed up Lordship.
No, the short issue here
Yes,
is that in terms of the recommendation,
yes, Lordship.
they are required to be given the benefits as given in the chart.
Lordship.
This chart, you'll find at page 61. This is the recommendation.
Lordship.
This recommendation shows that existing, whatever the salary was then proposed, which subsequently got replaced, everything is there.
Lordship.
Now, once a person is held to be eligible to be granted the revised pay for a particular period of time,
Lordship.
then the question would be, then the subsequent issue about getting further revised pay for those time slots after 5 years, after 10 years, after 15 years should automatically follow.
Yes.
He is in a particular slot. Court has come to a finding that he belongs to a different slot. The revised pay scale he is entitled to. Does it mean that he is entitled to only that particular pay scale and nothing more?
Subsequently, he will have the,
Subsequently, he will
he will-
have to get the benefit.
he will have the
So
enhancement.
here, from what the council has submitted is that since there is a direction by the court at para 30, I think, page number 26. This is the judgment under review. Page 30, it says that he is entitled to revised pay of rupees so and so to so and so with areas with effect from so and so in terms of the 5th CPC and corresponding areas with effect from so and so in terms of the 6th CPC. You've not got it?
Lordship, the pages are not telling, Lordship, right? Oh,
ডাবল পেজ দিতে পেয়েছো
Yeah.
26 yes
yes, Lordship, paragraph 30.
So this has given a direction that he is entitled to pay scale of 5,000 to 8,000.
Lordship.
And the department has only released that. The corresponding revised pay scale for the time slots which he has completed has not been released. Therefore, the review.
Lordship, let me clarify this thing with the,
Hmm.
let me clarify this with the department, but since quite some time, Lordship, he is not in service. So I have to,
No. Obviously, after his debited office, he is not entitled to.
Yes,
pay
yes.
scale.
So
the
till
period-
till he was there,
Till he was there.
I will take an instruction on that. I'll take an instruction on that.
So we will close it, giving you the liberty to verify and then release whatever is to be
If anything is due to him, yes.
due to him
Yes.
in the time slots.
Milo.
Yes.
Court, the finding of the court that he's entitled to this pay scale for 5th CPC, this pay scale for 6th CPC
Lordship.
was assailed before division bench and the Supreme Court.
Yes.
That was confirmed.
Lordship.
He is before this court that only this figure is given, the subsequent time slots have not been given.
But that would not be a review of the judgment, Lordship.
No. It would not be a review, but does it require a specific direction? Once,
It does not require lordship.
once it is identified with the court that is entitled, he is
Lordship.
entitled for the entire
Lord,
revised pay scale for till the time he is there in service.
lordship will keep it on Thursday, lordship. I'll
right.
just get it clarified, lordship.
Third counsel for parties is on Thursday. So far as the second matter is concerned, so this matter be listed separately before the appropriate bench by the registry.
Yes, ma'am.
For item number 2, Thursday. 3 separate order.
For admission, I think vote.
Yes.
Nurses matter. Nurses, my lord.
Nurse?
Nurse matters, repetition.
Ah.
There should be a common gradation list.
Ah.
So they did not make the common gradation list, so he came before the court.
Yes.
Interim order was granted.
Yes.
So that matter, I think my learned friend has filed application for the stay order. That's why.
His IA is thicker than your.
Yes, yes. Then my body. I am thinner
No,
comparing
not
to my
your
lord.
body. The miscellaneous application is bigger than the main writ petition. Yeah, anyway,
I know. That's what. Lordship is called for the records the other day.
what about the respondents? Who are for the respondents here?
Your lordship, I am for the respondent, private respondent.
No, state respondents.
State
Who are there?
respondent was there, they'll be coming, your
She
lordship.
was here just now. Lordship is directed for the records last occasion.
Your lordship, no records is necessary, I'll demonstrate before your lordship. That this writ petition is liable to be dismissed at the threshold, your lordship.
Right, let us first understand what is the writ petition.
My lord. Let me place it, my lord. My lord, petition is in nurses association, my lord. And the members, my lord, are given in Annexure 1. And there are others also, auxiliary nurse and others, my lord. Now, my lord, what happens? There is a rule, my lord. Give me the rules. Because basically, these are interpretation of the rules, my lord, here in this case. This is the rules. Lordship may first kindly see the rule, my lord, 2.1 in page number 2.
Page number 2 of,
Page number 2 of these rules, my lord. I
why have you not enclosed it to the writ petition? Yes, 2.1.
Yes, my lord. Lordship kindly see
Hmm.
2I.
Aye.
Service means Assam Nursing Service.
Hmm.
Then come to 3. 3 class 1, class 3.
Hmm.
B. My lord, matron, principal nursing, district public health officer, subordinate rural health, sister, water system, ward sister, tutor, public nurses, health nurses, public health nurses, staff nurse, auxiliary nurse, lady health visitor, supervisor, my lord.
You
They-
fall under which category?
I fall in the association belongs to auxiliary nurse, visitor, public health nurses. Those are my lord. That I have stated in my paragraph 2 of my petition.
Auxiliary nurse,
Midwife,
midwife,
yes. And also public health nurses.
public health nurse,
Nurses, my lord.
not tutor.
Not tutor, public health nurses. So, my lord, now if your lordship kindly see the rule 22, my lord,
Rule 22.
page number 11, my lord.
Yes.
A gradation list, rule 22, a gradation list containing the names of all members of the service in order of seniority, stating the cadre and such other particulars as to the date of birth, date of employment, caste, etc. will be prepared, published every year. This is the rule, my lord. So there has to be a, my lord, senior gradation list containing all the cadres. Here what happened, my lord, in this case? Cadre means lordship has seen class 3, I've shown, my lord, all these, my lord, employees have become to class 3 cadres. Here what has happened? When we file the repetition against they prepared 2 gradation lists, my lord. instead of 1, 2. And in that cadre list, there's no names were there, no date, nothing was there. And we have the impression that probably they're going to promote certain stuff from my lord, from the other cadres and all.
Hmm.
So we came before the honorable court.
Yes.
Remember that?
Is it? Yes.
My lord, we came before the honorable court. In this case, the director of health service, they filed an affidavit, my lord. They should be lordship, kindly see, my lord, my lord, that starts in page number 40. Page number 40.
Page number 40
40, yes.
of the writ petition.
No, this is an affidavit in opposition filed by them. Serial page number is page 40.
Filed by whom?
Filed by the, I think, health department, health. Director of health service.
All right. Yes.
Now, page 42,
Uh,
kindly see that, my lord, let me read paragraph 5. With regard to the statement, Mr. President, the deponent admitted the statements made in therein and begs to state that 2 numbers of provisional seniority list was published by this directorate, one for ward sister, ward church, 40 such and such, and another for public health nurses. The name of public health nurse belonging to preaching organization could not be included as director health service is not the appointing authority, my lord. Lordship has seen. This was the stand. Then subsequently, next paragraph, they said there's a mistake committed by them, so they have withdrawn that gradation list, my lord. Paragraph next 6. That with regard to the statement, paragraph 4, the deponent begs to state that the final seniority list could not be published in that calendar year due to some unavoidable reasons. As the seniority list is valid in that particular calendar year, therefore, the provisional seniority list published on 18/12/24 may be treated as invalid. So they've withdrawn that, my lord.
Both the lists or one list?
Both the list they have withdrawn.
Both lists. with-
Yes. Now, if your lordship see my prayer in the writ petition, now one question arises, my lord. If those 2 gradation lists have been withdrawn, then why I am before lordship still today, my lord? The reason behind it, my lord. If your lordship kindly see my prayer, my lord. Prayer in page number 10, my lord. But this is one question. If that is withdrawn, then why I am before your lordship, my lord? My prayer is setting aside and quashing the provisional gradation list, my lord, that has gone invalid. Next one. Direct the respondent authorities to prepare a common gradation list for sisters such and such, my lord, including 26 number of PHN. Here, my lord, there are 27 PHN really promoted from our public health, my lord, health visitor and the supervisor. 27 were promoted. Out of 27, 13 retired, 14 are still working. So I will press for, my lord, this one, to prepare a graduation list.
Number one, the provisional lists have already been withdrawn.
Withdrawn that one, my lord.
So therefore, the prayer number 1
Oh, no, is
not
obsolete.
required.
No, it's not required.
Right.
That's why I said, my lord, it's not required.
The second direction is to prepare a common gradation list.
So our graduation list, my lord. My lord, that common graduation list, my lord, they have prepared common graduation list now. Prepared, excluding us.
Why are you excluded? Where is
That
this?
is the reason, my lord, because there's a judgment of this honorable court that's in page number 34 by single judge. Yes, kindly see. This judgment is, my lord, there were gradation like these persons, my lord, staff nurse and the GNM, they were not included in the list. So they did not meet common gradation list and persons are promoted. Honorable High Court said, no, as per Rule 22, you are supposed to make a common gradation list. And the persons who have been promoted, we set aside their promotion. They have been brought down because for non-compliance of Rule 22, just like in my case.
Which paragraph?
Page 35, Lordship, kindly see now, operative part will be in page number 37, paragraph 11. The issue is not with regard to having eligibility to be promoted to the next higher post of assistant matron, assistant nursing superintendent, deputy nursing superintendent, but the principal conditions which were required to be followed before initiating such promotion exercise. It is the admitted fact that 2 graduation lists were prepared instead of 1 as contemplated by Rule 22 of 2091 rules. It is from the graduation list of ward sister alone that the candidates were considered and promoted to 71 numbers of vacancies in the said post. Such non-fulfillment of basic requirement has not only deprived the members of the association from a fair consideration, but appears to be an utter violation of the rules holding the field. In paragraph 13, my lord, the appointment has been set aside. Paragraph 13.
Hmm.
So my simple submission in this case, my lord, since there is rule 22 specifically provides there should be a corroboration additional list. Now, why our names are not included, my lord? First, lordship has seen the director says, I am not the appointing authority. Plus, please see page number 324, my lord. Their lordship will find the ANM from our, my lord, association, they are promoted by the director only. This is one legal issue, my lord, whether rule 22, my lord, about this.
Now, after this order, what happened?
My lord, this judgment, this was carried to division bench, my lord.
Hmm.
That was upheld, my lord.
Appeal.
Upheld, yes. I had the copy
That
the other
order
day, but.
enclosed here? No.
So basically, my submission is, my lord, 2DT should be followed, my lord. My lord, this is a different issue. Once they put me in the gradation list, my lord, whether I get,
Who filed the writ petition?
my lord, the nurses association, my lord.
Your association?
No, no, no. This is another association.
I was the counsel for the petitioners.
Petitioner.
This is not the exact facts what my respected senior has presented.
I'm-
I'll present the facts.
I am saying about the interpretation of Rule 22, not about the fact of this
That's
case.
a wrong
I
interpretation.
see. I know.
I'll justify it.
Now, lordship has seen in the affidavit of the government, the director says he could not do it because he's not the appointing authority. But in page 324, the public health nurses were promoted from my association, my lord. That order was passed by the director.
Typed, Lordship.
Hmm?
That is wrongly typed, Lordship.
What is wrongly typed?
That is,
Page 324 of the affidavit, my lord, my reply affidavit, lordship, kindly see.
Page?
In IM, my lord, IM
Uh.
324, page number.
No, are we hearing the IA or the writ petition?
No, lordship has asked about the fact. Lordship
Uh.
probably he's filed an IM, my lord.
Your lordship, I filed the I for stay vacating your
I
lordship.
know.
Hmm.
324.
324 in Lecture 1. Lordship, in the order dated something like 2/21, left side LHB, they are the my association members. They are promoted to the
Yes.
post of public health nurses under additional chief such and such, my lord. In partial modification of director order number, the following LHB, lady health visitors, are hereby temporarily promoted to the post of PHN under additional chief engineer such and such, my lord. Next page, can on the bottom, my lord, director of health service, signed by. Similarly, page 27 also saying, but in the affidavit of the government, my lord,
Hmm.
the director says,
Hmm.
my lord, the name of public health nurses belonging to the petitioner organization could not be included as director of health service, not appointing authority to them. So my learned friend said there's a mistake, my lord.
it's mistake, Lord.
But that order copy I have annexed, my lord.
So mistake in a sense that you admit that director is the employer.
Director is the,
How can you file an affidavit with a wrong statement? Yes, then
So my submission will be, my lord, since, to be very honest,
your submission is that there must be a consolidated seniority
clearly rule 22, my
before
lord,
you go ahead for promotion.
promotion.
That's
Promotion
okay.
is separate. I may get, I may not get, my lord. That's a different issue. If I come with a zone of consideration, my lord, if everything is there, fine, my lord, I get promotion. But the first criteria, the first step is, my lord, there should be a common gradation, my lord. That's
What
all.
if after withdrawal of the seniority list, has a new seniority list come?
Yes, come up, my lord, has come up.
It includes your name.
No, there also my name is not there. That's why I said paragraph 2, let it be there, my lord. In the hearing, lordship will have to decide this, my lord.
And there is no challenge to that.
Uh,
I'll answer, my lord, that, my lord, about the challenge part.
Yes, let us hear the government first. What do you say? What is the issue here?
I have filed the affidavit, Lordship.
Where you have made a wrong statement. which you now
That
admit.
is actually, the director is the appointing authority, Lordship. My typing mistake is, I have done the wrong, Lordship. Lordship, may see page number 42, para number 5, Lordship.
Hmm.
The provisional seniority list was published by this directorate, one for ward sister, ward in-charge, OT nurse, nursing sister, a sister tutor, etc., dated 18/12/24, which was Lordship already. Already cancelled, Lordship.
Yes.
Then, Lordship, as the seniority list is not valid, Lordship, already,
So now you have come up with a new seniority list. That is what he submits.
yes, sir. Following the Guwahati High Court order dated 16/12/22, again published the provisional common seniority list in the departmental website, Lordship,
Uh,
on 3/1/25.
uh,
And thereby it is informed that if any claim or objection arises in this seniority list, Lordship, directed to report for verification, rectification. There was no objection from the petitioner's side, Lordship, petitioner's association. So authority published the final seniority list on 5/2/25, Lordship.
Is it under challenge?
Then that is
We have
not. yet.
challenged.
Huh?
Lordship is
That-
notice in that case.
Huh?
We have challenged that.
Is it under challenge in this petition?
That new gradation, that my lord list, gradation list.
No, no, in which writ petition?
My lord, that's 6016 of 25.
Where is
It's a
6016?
separate writ petition,
Separate
not
petition I filed mine.
clubbed, not clubbed.
We have challenged that.
Yes.
New
You have
gradation.
challenged
We
it.
have challenged.
Yes, that is challenged in another writ petition, Lordship.
Notice has been issued in that case.
Now, why are the names not included?
In that case, I have not received the instructions, Lordship. In that case, Lordship.
That is the only issue now, my lord, pending.
No, now in this writ petition, what claims are alive?
My lord, so far,
If you have challenged the.
lordship is,
challenged the-
lordship is right.
If you have challenged the new gradation list.
Yes, yes,
Where your grievance is that your names are not included,
yes.
Lordship.
then you are raising all these issues before that.
That's why in the beginning, I honestly submitted
Huh.
that paragraph 1, my lord, was my prayer, my lord.
Huh?
That has gone.
Huh.
So far, 2, my lord.
601.
I feel, my lord, let it be, my lord, alive, because this may be tagged with the other one, my lord. Because this is the issue, my lord. Repeatedly they are excluding us from the list, my lord.
No, no,
So
but that is already taken up in the other writ
I
petition.
have taken up that matter, my lord, that's what.
Then
That's
you
all.
don't need
That's
two
what
writ
we have
petitions with the
separately,
same prayer,
I
with the same petition.
live your lordship. I lived here, that's why at the beginning. I didn't press that hard, my lord, that's the reason.
And
I
there,
placed
there
it.
is perhaps no interim order in that writ petition.
No, for interim, my lordship is fixed.
No, in that writ petition. The second writ petition, there is no interim.
No interim order, but lordship is fixed for passing interim order next day.
When is the matter fixed?
Tomorrow it is come, but it's come to a court where I think my London, that honorable court may not take up the matter.
Hold that.
It should have been come here,
Therefore, in this writ petition, nothing is to be decided.
Lordship.
except that I'm just thinking about part 2, that there are 2. Yeah, I leave to lordship's mind. 2. Because first though it doesn't survive, my lord. 1, it doesn't survive at
No,
all.
See, in two.
And this is also there in the new petition.
We-
That's
we-
true. That's true.
If your prayer is number 2,
Hmm.
then we can close the writ petition with a direction to consider in terms of the earlier order passed by the court.
But that again, second one is coming.
Second one, we don't know.
Yes, that's what.
When is the matter listed?
Tomorrow, it was listed the last, which date it was? Notice? It is around 10-12 days back, my lord. Tomorrow it is coming up, my lord.
So let it be listed together tomorrow.
Tomorrow, my lord. Yes,
In this court, we'll take it up again to decide.
yes, yes,
Your
yes.
Lordship, I have a small submission, if you'll kindly permit.
You are a party there in the other writ petition.
No, no, no.
Not a party.
Perhaps they have arraigned me as a party respondent, but I have not received any notice. Your Lordship, this entire writ petition has been filed before this honorable court. concealing the material facts, your lordship. I'll just draw your lordship's kind attention to the prayer portion.
Yes.
The first thing they have challenged, your lordship, the first ground of challenge is that there has been two gradation lists.
Hmm.
Your lordship, these two gradation lists were published on 18/12/2024. Nowadays, all gradation lists are published in the official website, your lordship. It is available to everybody. On 19/12/2024, those two lists were cancelled. And by the time the petitioner came before this honorable court with this writ petitions, they were aware of this fact. Now my respected senior is saying that those two lists has been cancelled. But I can show your lordship that those two lists were cancelled way back on 19/12/2024. And a provisional gradation list was published on 3/1/2025 and the final gradation list was published on 3/2/2025. If your lordships kindly takes up my stay vacating application.
Yes.
Your lordship will kindly turn to page 248.
Yes.
On the basis of the objection claim for rectification of provisional common seniority list published on 3/1/2025, the final common seniority list of ward sister, ward in charge, nursing sister, OT sister, sister tutor under DHS, DHS FW and DME and PHN only under DHS Assam on the basis of last date of joining at present post is published herewith on 5th January 2025. So this was published, your lordship. No, these facts were suppressed by them, your lordship. Now, if your lordship takes up their affidavit in opposition, which they have filed in the stay vacating. Page 324, 325 and 328. From 324 to 328, these are three promotional lists to the cadre of PHN. Now, before I make my submission, I'd like to say that the very issue of promoting to them the ANM nurses to the cadre of PHN is under challenge before this honorable court. And there is a stay operating against them. And therefore, they want to stall the entire selection process. That is their main idea behind this. Now, if your lordship see page 324, this is the first promotional list to the cadre of PHN, 11/2/2021. Then the next one is at page 325, 8/11/2021. And the third one is at page 328, that is 7/1/2022. So they were promoted way back in the year 21 and 22. Thereafter,
Who are these? These are the petitioners.
these are the petitioners. They have been promoted. This is their own documents which they have filed. Now, they have been promoted way back in 21 and 22. Thereafter, 3 gradation lists were published, final gradation list, and 6 promotions were taken place, which they have not stated before this honorable court. Why they have not challenged that gradation list? And till today, they have not challenged the final gradation list, which was published on 3/2/2025. If your lordships kindly come to page. I've annexed those gradation lists.
No, who are you?
I am the graduate nurses, your lordship. Your lordship, I'll just say the entire scheme of the things.
No, first tell us who are you?
We are the graduate nurses, sister
Graduate
tutor.
nurses. You, according to the rules, you also fall into the same category, class 3.
Yes, your lordship.
Class 3 category.
Yes, your lordship.
Now for which the seniority list is there, your names are there.
Yes, your lordship. Their names cannot be there, in fact. That is my humble submission, your lordship.
But that you challenge it before some by way of a proper application, but
No, I am not required to challenge that, your lordship, because their names are not there already included.
we are saying their names cannot be there.
No, in fact, the names are not there.
That's a different issue. We want
Yes.
to know your grievance, essentially. You are
Yes.
a graduate, you belong to class 3.
Yes, your
Your
lordship.
names appear in the
Gradation list.
gradation list.
Yes, your lordship.
What is the stage for promotion now?
Now, the next cadre is vice principal and assistant matron.
You are eligible for that.
Yes, your lordship.
And what is the stage of promotion, madam?
Your lordship, after the gradation list are published, on the next promotion should be taken care of.
Hmm.
And there are 160 odd posts, 140 posts are there still vacant.
Hmm.
Because of this order, in the guise of this order, the DHS is not promoting us.
No. What is how many posts are available? 160.
140.
140.
Yes, your lordship.
And what is your serial number in the seniority list?
That I can say, your lordship, right now. Just a minute. Your lordship, I am at 54, 55, 56, then 83, 84. Serially, I'm there. I'm just saying there are 87, 88, 89, 90, 108, 111, 112, 114, 115.
And what is the stage of promotion now? Have you taken any steps to?
The vacancy position, Lordship. Vacancy position in matron nursing superintendent is 32. Principal tutor 5.
No, আমার কেন বাইদেউ?
They are eligible for which post?
Assistant matron and vice principal.
Assistant matron is 65, Lordship.
55.
Is 65.
65.
65. And vice principal 2. Yes. Ward sister is 101. And sister tutor
সেইটো নালাগে।
52.
PHN to
তোমার PHN to লাগে না?
PHN.
PHN is 31.
Now you are where is the class and cadre for promotion reflected? From which post are you promoted?
Your lordship, then your lordship has to go back to the rules, your lordship.
So you are now in which post?
I am sister tutor.
Sister tutor. So your next promotion would be superintendent, rural training.
No, my next promotion will be assistant matron. Your lordship, it is like this. Sister tutors are the one who teach in the nursing schools. And
So
their
we are
equivalent.
going by the rules.
Yes, your lordship.
If you come to schedule 1 of the rules,
Yes, your lordship.
it shows the equivalence of posts.
Yes, your lordship.
So if you are a sister tutor,
Your
you are a
lordship.
sister, your equivalent post is public health nurse and assistant superintendent.
Yes, your lordship.
So you can't be promoted to any of them because they're equivalent.
No.
Your promotion has to be to the next higher post,
Yes, your lordship.
which is either superintendent or district public health
No,
or principal nurse.
I'll clarify to that extent, your lordship. If your lordships kindly turn to page, the rules. Rules 11, your lordship. Has your lordship got rule 11? Appointment to the cadres of matron, assistant matron, sister, lady health visitors, and their corresponding equivalent post as shown in Schedule 1 shall be in the manner provided herein under. The appointing authority shall prepare this. I'll skip. Then I'll skip the.
Now come to schedule 1.
Yes, your lordship. Now, if your lordships comes to Schedule 1, your lordship will come to Schedule 2, your lordship.
So come to schedule 1 first.
Yes, your lordship.
Now from there you tell us from which post the person is to be promoted to which other post.
No, I'll come to Schedule 2. Why I'm saying so? That post we are not claiming, your lordship. If your lordship sees class 3 matron, principal nursing officer, district public nurse health of supervisor, these are equivalent posts. There has been a change in the nomenclature of the post. These are equivalent posts. These are same category. Now your lordship will come assistant matron, assistant superintendent. These are the same post. Now 10, 11 and 12, that is public health nurse, sister tutor and ward in charge. These are equivalent posts. Your lordship, the entry cadre is staff nurse. Thereafter, the next promotional post is ward in charge or sister tutor. The sister tutor, the teaches in
From where are you making this submission? The rules do not say so. Are there any office memorandums, notifications? The rules are not clear on this, from which post you are to go to which post.
we are required to be promoted to the cadre of your lordship. In fact, the gradation list itself says so, your
That is,
lordship.
therefore I asked you to come to Schedule 1.
Yes, your lordship.
Schedule 1 has some clarity that from sister you can get promoted to matron.
Matron is the top post, your lordship.
So matron has got different equivalent
Yes, your lordship.
posts.
Yes, your lordship.
Now you're claiming that from 10 you have to go to 9 or 8 or 7. On what basis are you making this statement? The rules are not clear.
Rules are very clumsy. Lordship is right, my lord. Rules are very clumsy.
Hmm.
Very clumsy.
You challenge the rules if you think they're clumsy.
Not only me, my lord, for everybody.
So why are you not challenging it?
For him also same thing. Let us join together, my lord.
No. For me, the
Council for parties, this matter be, as it is submitted, that another matter is listed tomorrow,
My lord, tomorrow.
being WPC number
6016 of the 25.
6016 of 2025, which has been filed by the same petitioners, challenging the final gradation list.
Yes, my lord.
Final gradation list.
Yes.
Dated
3/2/2025, your lordship. Otherwise also this writ petition does not survive at all, your lordship.
That's
In
right.
the face of it.
So it will be dismissed tomorrow.
Your lordship, perhaps that bench may not be able to take up this matter.
Why?
Nair there go to the because Justice Nair appeared in this case.
Then it will come before whichever
We can mention. We'll make a mention. We'll tell the honorable court.
bench it comes.
Your lordship will, your
No,
lordship,
we are asking you one thing.
Yes.
You are filing an application seeking vacation.
yes, your lordship. Right, your lordship.
Now you tell us how your rights are affected in terms of promotion, which has been curtailed by the interim order, for which you are seeking a vacation.
Your lordship, in the guise of this interim order, basically there does not exist any interim order. In my humble submission, with respect to the promotion to the next higher cadre.
Huh.
But in the guise of this interim order,
Because the interim order is clear that
page 37, your lordship.
the interim order is not to proceed to give effect to any promotion from separate provisional list.
Yes, your lordship. That is my case, your lordship.
So as on date, there is no separate provisional list.
No separate provisional
There is
list.
a new final list.
Yes, your lordship.
How does it affect you?
In fact, your lordship, this provisional list did not exist when they approached this honorable
How
court.
does it affect your?
Your lordship,
claims?
in the guise of this order,
Huh.
the DHS is not promoting us. Your
Then you
lordship.
file an application seeking a direction to the DHS.
Your lordship, therefore, we are before your lordship that your lordship will clarify to that extent that there is no embargo in continuing
Why
with the
should we,
promotion.
when there is a separate writ petition filed where there is no stay subject to correction?
Exactly, your lordship. Your lordship, that gradation list, they should have challenged all those gradation lists.
We don't know what they.
And
should
they have
done.
not
We are
arrayed
here to
anybody's-
Give legal advice to anybody.
Yes, your lordship.
Where we are saying that according to you, certain facts were not placed, whatever, there was an interim order. But
Right.
the interim order is restricted only to the extent of not to promote from separate provisional lists. That provisional list as on date has already withdrawn. So therefore, you have a final list, which is again under challenge, where there is no interim order. If your cases are not considered, your remedy lies elsewhere.
Your lordship will clarify in the
Why-
order
why
to that
should-
extent.
why
Because
should
in the
we-
guise of this order, they are not promoting your
That-
lordship. They
where-
are not exercising the promotion policy.
No, on what basis?
Your lordship, they
On
have,
what basis are you making a statement that the government is not, is interpreting this order in a different?
otherwise I would not have been before your lordship, your lordship. Impleting myself, then coming up with a stay vacating application. This is a tedious effort, your
We'll
lordship.
examine it tomorrow or whenever the other matter comes up. Let both these matters be listed together.
Your lordship, that matter has nothing to do with this. Because neither there is an interim order, they are challenging the gradation
Yes,
list.
government, what do you say? What, why have you not proceeded with the promotion?
Okay, to Rani Hassan, is it?
This is
Stay
the grievance
Yes,
appears to
Lordship,
be
in
against
this
the
case.
government.
Stay order is there, Lordship.
What stay order?
In this case, Lordship, present case.
Have you read the stay order?
Yes, Lordship.
So what does it say? What does it say?
It was.
You're seeking promotion from the basis of a gradation list. There is no stay against that gradation list.
It was order, right? It order.
List these matters again tomorrow.
Your lordship,
On so and so date. Along with WPC number so and so. Both the WPC and IA. Yeah.
your lordship may clarify to that extent because they are
We'll
also.
clarify once the matter comes up together.
Okay.
Otherwise, we see no reason effectively this writ petition has become infructuous.
In fact, your lordship, the day when they approached this court, that provisional gradation list was not there. That was an impression given before this honorable court.
Nine
but-
25, Lordship.
Huh?
Order dated 25/9/25, Lordship.
Hmm.
It was stated, directed no promotion to the next higher post from those provisional seniority lists will be effective till the next returnable date.
Which provisional seniority list? Which you have already withdrawn,
On 19/12/2024, they have withdrawn it.
Yes, yes.
then? There is nothing about the final seniority list.
Lordship,
Why are you blaming the court?
please.
Where is the restraint?
And in fact, your lordship, this sort of concealment of fact should not be there before this honorable court. They've come up with this writ petition saying the two provisional gradation lists, as if they have given the
Your
impression.
grievance is against the government for not implementing your promotion.
As an officer of the court, I have to raise the grievance
No, you
when
raise
something
it, we appreciate that, but essentially your grievance is against the government.
in the guise of this. And
We don't know what, but.
And
you have
this
not-
is an offshoot of.
Have you filed any application before the government to say that this interim order does not affect the promotion now in view of the final seniority list? Nothing. Have you?
That part I have to take instruction, your lordship.
You have to take instructions because you know you haven't filed.
But otherwise also, your lordship will just look into the
You
scheme
are,
of these
you
things.
you want to get into an academic issue. We want to pass a final order so that
No, this is an open and a shut case, your lordship, because they have approached this honorable court with two gradation lists,
That's
which
right.
does not exist. Is it not concealment of material facts before this honorable court?
no,
Now they come up and say only when I filed this affidavit.
no, that's right, but
That-
it doesn't.
now they
doesn't
admit it.
affect you.
No, this
Does
is
it affect you?
indirectly it is affecting me, your
How
lordship.
does it affect you?
Your lordship, just now the standing council has said in the guise of
As the
this.
standing council, have you approached the government to say that in view of this order, how can you withhold my promotions? Have you? No.
Your lordship, we have
Have you
verbally
filed an
approached.
application against the government to say that there is no interim order? In spite of that, they are withholding to the promotion. They are not taking up promotional issues. You are an officer of the court. You are aware.
I'm honestly confessing, your lordship, to that extent, I am not sure. I will take an instruction,
Then
but
if you're not sure,
whether they have filed or
Therefore-
not.
Therefore, we want both these matters to be listed together so that we are sure what order has been passed and what order needs to be vacated. It is as simple as that. So list it tomorrow. List Hertz once is also in Mr. Sinha in the IA. Mr. N. Nath, Senior Counsel in the writ petition. MSG Bora, Standing Counsel. It is still in the course of the hearing. He submitted before the court that the writ petition, that the final seniority list for class 3 nurses under the Assam Nursing
Service,
what?
Assam Nursing Service Rules, your lordship.
Assam
Nursing
Nursing Service Rules
Services.
1991.
Assam Nursing Services have been published under the Assam Nursing Service Rules 1991. Therefore, and the said list is also under challenge in WPC number
6016.
6016
Public 25.
25, filed by the same petitioner. It is also submitted that this matter is listed tomorrow. This matter, the petition is listed tomorrow. Considering the matter in its entirety, let this matter be listed along with WPC 6016 2025 tomorrow. Further orders where required will be passed. That's it.
Item 5.
Yes.
May I please, your lordship? My lord, the petitioners, my lord, are eligible and qualified, my lord, to undergo the recorder's certificate class post training, which we popularly call them as mandals, my lord. So, my lord, and for the purpose of the safe training, my lord, an advertisement had been issued. My lord may be pleased to find the advertisement, my lord, is at page 34. Lord, in this advertisement, along with the other conditions, my lord, in no case eligibility of candidate, my lord, I am referring educational qualification, the candidate must pass HSLC examination or its equivalent as recognized by the government of Assam, and age criteria has been given. And the plan of selection test has also been notified, and the standard of examination has been given. The written examination will be said. So, my lord, in this case, advertisement, there is no provision has been made that there should be a reserved category or open category. It has been combined, my lord, as a one category of all the candidates, my lord. Now, my lord, responding to this, when we applied, my lord, we were allowed to, my lord, go through this interview, and accordingly, my lord, we had also been found as select list, my lord. My lord may be pleased to find the select list we have annexed, my lord, is at page 42, annexure 6A, my lord. Now, my lord, this is in fact the result of the unsuccessful candidates for undergoing the recorder so and so. In this case, my lord, our name has been reflected, my lord. And if we go by this select list, my lord, then we can found, my lord, that there are category has been shown as the general, OBC, STP, and this, my lord, both vertical and horizontal reservation had been maintained. Now, my lord, as a result, what has happened, though, my lord, we have scored more than this reserve category candidate, but by, my lord, treating us as a, my lord, a general category candidate, we have been ousted. Now, my lord may be pleased to find the name of the present petitioner, my lord.
Yes.
Yes, my lord. The name of the present petitioners had been included here, my lord, in serial number. Ahmed Nawaz.
No, what rule has been changed?
My lord, the rule, we have said that once the, my lord, there is no notification as regards that there will be a reserved category or unreserved category, my lord. And then after the selection is over, then they have come up with this rule, have published the select list, my lord, basing on the reserved and, my lord, general category candidate, my lord. That rule is not originally there in the advertisement, my lord.
No, but it has to subscribe to the, that's a law.
No, my lord, that is the law for the purpose of only when recruitment or the appointment in the service
No, was
will
it
come.
advertised that all these posts will be for unreserved?
No, this is not the post for the, my lord, appointment for post, my lord. This is a notification for the purpose of
Training.
undergoing training, my lord, training. So therefore, my lord, my respectful submission before my lord is that the Assam Scheduled Caste Reservation of Vacancies Act is generally applied, my lord, when there is a recruitment drive is going on, and this drive is only for the training, my lord. So, my lord, that's why this rule of the game has been changed, by wherein, my lord, our marks has been shown to be a lesser than the other category candidate, my lord, who has been selected. So therefore, my lord, they have come up with an affidavit, my lord, wherein they have say, my lord, denied that there is no change in the rule of the game and the reservation is also applicable for the purpose of, my lord, these training courses. Now, my lord, exactly in a similar line, my lord, our honorable court has already similarly situated candidates case, my lord, had been decided, my lord.
My lord, this rule is no more, my lord, it's already been repealed. My lord, new rule has been come. Earlier, my lord, that the RCC training, my lord, they have to first go for the RCC training, then they go, got the appointment for the, my lord, Mondal, I mean, or
When was
Patwari.
it repealed?
Repeal on, my lord, 2023, lord. New subject, my lord, new rules has been come, lordship. Now, my lord, as per this rule, lordship, the after the direct appointment, my lord, the selection, then, my lord, they go for the RCC training. Lordship, I have been marked, lordship. Now, my lord, earlier it was, my lord, the matriculate. Now it has been, my lord, the graduate, lordship.
My lord, this rule is a prospective effect, my lord, and our advertisement is prior to this rule, my lord.
And, my lord, that selection and other thing already been completed long back,
They
lordship.
have been put up for training subsequently.
No, my lord, we have not been put up for training because, my lord, we have been not selected for the training, my lord. That's why we cannot go for the training. Now, my lord, if we go by this rule, a new rule, then, my lord, we will not be qualified anymore, my lord.
Why?
Because, my lord, the qualification criteria, graduation, and other stringent conditions are there.
You are not graduates.
No, my lord, that's the problem.
You are now serving as mandals.
They are not serving.
We are not serving, my
They are
lord.
not serving.
My lord, the issue is like this, my lord. In the earlier set of rules for the purpose of this RCC, my lord, the person concerned who wanted to be this mandals, my lord, they are first required to go pass out the training. Along with their professional, my lord, qualification, this academic, this training course is also required, my lord. So once those persons who are trained for this course, my lord, then they will apply pursuant to an advertisement or they will be recruited, my lord. Without this training, a person is
First,
not,
there is a training.
first there is a training, my lord.
Then appointment.
Earlier, my lord.
Now,
Now, my lord, they, as per the new rule, first, my lord, recruitment, then training, my lord. And for the purpose of the recruitment, graduation degree is mandatory, as per their, my lord, professional academic qualification, my lord. So now, my lord, if we go by this new set of rules, then, my lord, this will be difficult for us. Admittedly and fairly, I am submitting, my lord. Secondly, my lord, when the earlier advertisement which we were, my lord, we did apply is based on the earlier rule. Now that's the cause of action arises when the earlier rule was surviving, my lord.
no, correct.
My lord.
Now, with effect from 1st of April 23, the new rules are
New
there.
rules are there, my lord. New
Now,
rules are there.
assuming there is a direction to put you up for training also.
My lord.
Then also you have to satisfy the criteria in the new rules.
No, my lord, because if my lordships decides, my lord, basing on the earlier rule, because this new rule has come up after filing of this petition, my lord. So cause of action still survives, my lord, basing on the earlier rule, because the rejection which has been made basing on the earlier rule, my lord. And this rule will obviously run prospectively, my lord. That's my,
This rule will run prospectively.
my lord, my lord.
But
My lord,
once the rule has come into force,
that is correct, my lord. That is
whether
correct.
it will be conducive to apply the earlier rule which has been repealed
No, there is,
to
no, my lord.
ensure that persons who are otherwise unqualified under the new rule should be given
The
an
benefit.
opportunity under the rules which are not in existence anymore.
No, because, my lord, our substantive right, which has been violated, was earlier, prior to coming out of publication of
No,
this rule.
essentially what you are saying
Exactly.
is that whatever rights accrued prior to the earlier rules
Yes, my lord.
must be given benefit in the earlier rules?
Earlier, that has been given by this honorable court, my lord, to similar set of persons because, my lord, the judgment has been delivered
Hmm,
on 23/1/2024, my lord.
hmm.
After this rule has been notified, my lord.
What is the penultimate direction?
Penultimate direction, my lord, may be pleased to find, my lord, it is in view of this stand disposal of with a direction upon the respondent numbers 1 and 2 to permit the petitioner number 1 to participate in the next RCC training program to be conducted by the respondent number 2 without insisting on any further eligibility condition from
So what is,
for
what
him.
is the effect? What will be the effect
My lord.
of this order? What is the benefit that you accrue?
The benefit, my lord, I will go the training, my lord. Once I passed out the training, then I will be eligible for the purpose of, my lord, applying or
This is not clarified in the order.
no, it has not been clarified. It has not been
The
clarified.
rule- This order only says you should be put up for training.
Then, my lord, I will go for training. This
Training is
petition
long back,
also-
it is over.
Huh?
I can understand my lordship's query, my lord. My lordship says that
Once
even,
even if you're, see, now the rules are first get appointed,
My-
then go for training.
my lord,
Earlier rules was just the reverse. Get a training.
Training
qualify,
first,
then you are.
then
you are
recruitment.
appointed. But in these rules, there is an enhancement of the educational eligibility.
qualification,
You are entitled to challenge it if you're well advised to do so.
my lord, my lord.
But giving you a benefit to go and attend the training will not give you a benefit for appointment under the new rules.
No, my lord, but that training will definitely help me, my lord.
You're not appointed.
They will not get any.
How will you be appointed?
No, my lordship's query is that as per the new rule, there is a enhancement in the qualification, my lord. Until and unless I fulfill that qualification, I cannot go and apply, my lord.
Right.
That is my lordship's query, my lord. Perhaps, my lord, this person has in the meantime may become graduate, my lord.
Then let him apply under the new rules.
No, my lord, under the new rules we apply, my lord, then it will be, my lord, this if training is already there, like the other candidate who are with similarly situated, my lord, they are also applying under the new rules with their training already there, my lord.
Mr. Hendik, what has happened to this matter?
My lord,
They have undergone, my lord. My instruction is that they
my
have.
lord, that training is already been
No,
over.
there is an
No, my
order.
lord, he got the, my lord, the highest mark than against the other person also. Lordship may kindly goes to that.
No, he got highest mark, we agree.
But
But
even
this-
then, lordship, as per the advertisement, my lord, that
No,
lordship.
please listen to the query of the court. Your rules were in effect from 1st of April 23.
23 lordship,
The judgment came on 23/1/24,
23, 120.
well after the rules are enforced.
Lordship.
The judgment is not an authority for interference or interpretation of the rules.
Lordship.
It has merely said so and so is allowed to participate in the next available training program.
Last page. 24.
Lordship.
Now, this obviously means that this direction was given keeping in view the earlier rules,
Lordship.
which on the date of the judgment was not existed.
That
Now, what is what benefit has been accrued to this person? You get your instructions,
Lordship.
find out what has happened, or have you filed an appeal, or what has happened?
Father, it is not a matter of only the petitioner. Lordship kindly see 47. The successful candidates, those are selected, there are also Malay reservation. In all districts, not only for particular Kasar district, in other district also reservation is there. So the one is made like that.
You're referring to?
Page 47. These are the person selected, 21 to 22. These are the lordship kindly general OBC, Kamru district, Lokhimpur, Madhuri, Suwepur. All districts are doing that. Only the petitioner, only for petitioners, well, Kasar district.
No, that is not our query. Our
Even
query-
then, Lordship may kindly goes to the annexure C of my affidavit, Lordship.
Hmm.
Page 78, Lordship.
78.
Lordship.
Yes.
The vacancy position was on my lordship, serial number 20 is there.
Hmm.
Out of 20, my lord, the selection was made only 19 lordships. Only because of that, my lord, this person was allowed to, my lord, go for the training lordship.
No, someone. No, there are two persons here.
Lordships. One has already been completed, lordships. Lordship, may kindly see the last but second para, lord. The two petitioner number 2 have already been completed RCC training program. It is only the petitioner number 1, lordship. He was left from that. And this, my lord, the training already been completed long back, lordship. But no, my lord, father knew or a training, my lord, is held on the, my lord, the training center. নাই দাদা। 92 ওপৰ আছিল না। এইটো আছিলে না।
There was some selection held earlier.
Lordship.
You successfully completed.
Prior to this, my lord.
Huh?
My lord, my lord. No, my lord, we only for the, my lord, for the purpose of training, my lord.
I know for the
But-
purposes of training is there is also a selection process.
Lordship.
My lord, coming to this, my lord, merit assessment, my lord. Before that, there are some.
On the merit list, my lord, this selection, my lord, this list has been, my lord,
Your name appears in the merit list.
no, my lord.
No.
And then
Which merit? No, earlier
we are
there
going
was.
by the judgment you have placed.
My lord, I know, my lord. My contention, my lord, is that in that judgment, my lord, that the reserved category and the unreserved category has been explained, my
No,
lord.
no, no. That judgment, the petitioner before the court in the judgment,
My lord.
and you are placed in the similar situation.
My lord.
They were also presenting themselves for the training,
Yes, the same, my lord.
same training.
Same
But
training.
can we read the second paragraph?
Yes. On 22/1, the Director of Land Record, that is the respondent number 2, herein had issued an advertisement. Notice inviting application from the intending candidates to undergo 6 months recorder certificate class course training to be held in the Assam Survey and Settlement Training Center, so and so, for the session 2020-21. In response to the said advertisement notice, the petitioner numbers 1 and 2, along with the several other candidates, had applied for the training program. Thereafter, they had taken part in the selection process, which comprised of a written test and viva voce examination. Upon completion of the selection process, the respondent number 2 had published the list of 19 candidates who had participated in the process, including the 2 writ petitioners, along with the marks obtained by them. Yes, Miller. We did also participate.
You
Miller.
participated.
Yes, we did also participated, and that's why the select list had been published, Miller,
Hmm.
wherein we have been shown.
Your names have been mentioned there.
No, my lord, our name has been rejected only because of treating us as a general category candidate, and therefore we could not come in the merit list, my lord. As we marked,
Therefore you read this. Leave the last line,
my lord,
second paragraph.
the respondent number 2 have
No.
published
No, last line of the second paragraph.
in
Upon
process.
completion. For the judgment.
My lord, last line, yes, my lord. Upon completion of the selection process on 24/9/21, the respondent number 2 had published the list of 19 candidates who had participated in the process, including the 2 writ petitioners, along with the marks obtained by them. Exactly, my lord. Our my lord, candidature had also been published, my lord, wherein we have been shown, my lord, but these 2 candidates has also not been, my lord, shown as a past candidate, though their names had been, my lord, included, my lord. Because, my lord, as per the select list, the petitioner number 2 herein had secured the highest mark of 88.33, whereas the petitioner number 1 had secured 84.33. Notwithstanding the same, the petitioner numbers 1 and 2 were not allowed to participate in the training program, although there were as many as 22 seats. The petitioners were denied admission in the training course, apparently on the ground that 16 out of the 22 seats were allotted to reserved category candidates, whereas both the petitioner belong to the general category.
What happened to these
My
people
lord.
after the order? They were allowed to participate.
Yes, was one of his.
Well, let him take instruction regarding what they have been doing after this. I think, my lord, they allowed.
If they're allowed, then how are you applying both the rules, new rule, old rule?
My lord, only because of that, my lord, this is for my lord, their training. Now, my lord, new rules come, my lord, as because, my lord, they have,
No, we want to know pursuant to this order.
lordship,
The order is very clear that you have to permit them to participate.
lordship.
This reservation is not maintainable.
On that time, my lord, that training session is going on. My lord, now, my lord, training session is
No,
over,
no,
my lord, that's why.
Training session, even if the training session is going on, your new rules were in place.
Lordships. My lord, that rule was, I think, my lord, that was not come, my lord, we could not place on that time, lord.
No, it is notified on 27th.
No, that is notified, my lord, that is not with published, lord. It is notified,
Is the Gazette notified
lordships.
on 27th March?
Lordship, that is 27 March 23, lordship. The effect from first April, my lord, we could not brought out this, my lord, the notification that time, lord.
Therefore, you tell us what.
Lordship, let me take instruction regarding. And my lord, this is the regarding my lord, the selection procedure for the training, my lord. They have
When can you get it? Friday?
by the next week, lord.
Next week. This matter again on 28th.
My
28th, enabling Mr. Hendik, Leonard, counsel appearing for the Revenue Department, obtain instructions as to the status of the employment of the writ petitioners in WPC 5932 of 2021.
5937, my lord, 2020.
5937 of
Fine.
2021. And in terms of the order dated 23/1/2024, passed in the same writ petition.
My lord.
List on 28th.
Oblige, my lord.
I
And
for
here
approval
we have
you
petitioner, Mr. T.C. Sutia for
three respond.
respondent number 3.
Item 6 and 7.
Yes.
My lord. My lord, this is a case where, my lord, I have been terminated on the basis of an FIR made on the false allegation and on the basis of a charge have been framed. And there, kindly
What?
see page 20.
Inquiry was held.
Yes, my lord, kindly see page 27 of the writ petition. This is there, the following charges are brought against the delinquent Uttam Kumar, Guwahati. May I read, my lord?
Well, let us see the inquiry report first.
This is the inquiry report, a part of it, I
This
sent.
is the inquiry report.
Yes, my lord. This page 26 starts, my lord, inquiry report. So here the charge framed, and on the basis of the charge for allegation of the rape and others, my lord, the last part, hence UBC so and so is charged with gross misconduct and dereliction of duty, and this renders him unfit to retain in disciplinary police force. But on the basis of this, my lord, subsequent notice has been served, Tocco's notice has been served. The reply of which I have also submitted, Annex Chart 6, page 36. Where I have categorically denied page 37 onwards. First para, second para, I have categorically stated the facts, what actually happened there. Thereafter, my lord, ultimately on the basis of this inquiry report, page 39 and Annex 7, I have been terminated. Page 39 and 40. My reply has not got any due weightage from the respondent, and ultimately I filed an appeal also as per procedure. This appeal is also dismissed, my lord. That is page 41, 42, Annex 8. During pendency of this suit, my lord, I have filed another additional affidavit. During pendency of this suit, the
Pendency of?
this suit, my lord, this case before High Court.
Ah.
Subsequently, the matter goes to the criminal court, and learned session judge, my lord, has categorically passed this order determining some points, which is page 60, 61, my lord, kindly see, of additional affidavit. whether the accused persons in furtherance of their common intention committed gang rape on the victim, whether the accused persons in furtherance of their common intention put the victim and her associate, namely Lalrindinka, in fear of injury, whether the accused person in furtherance of their common intention wrongfully confined the victim and her associate. My lord, here also PW1, PW2 and 3 examined, my lord, but during cross-examination of the prime PW1, my lord, that is page 61, last para number 10, which is the informant. She deposed in his evidence that she is the informant in the case. She does not know the accused person. Same informant during cross-examination at the last page of page 62, kindly see, my lord. During cross-examination, she deposed that she does not know the who write the azar. The accused standing in dock today are not the person who committed rape upon her. The person who committed rape upon her were one fat and one thin. She saw nameplate in the wearing apparel of the miscreants, but the name has not been mentioned there. The railway station is a very long one and there are so many test rooms and there are always rest station. After the occurrence, she did not visit the PO as it was dark and she cannot remember the restroom concerned. She has no grievances against the present accused person. PW3, PW4, my lord, their evidence has not been corroborated in this case, my lord. That is categorically stated in the judgment.
No, which judgment you are referring?
That is, my lord, additional affidavit I have filed annexing the.
This is the judgment of the criminal case.
Yes, my lord.
You are now before the court challenging the departmental proceedings.
I am going there, but there is a linkage between, my lord. Why I am
What
saying?
linkage? These are on independent.
My lord, I want to say, my lord, I have been honorably acquitted from this. That is my
That is
statement.
before or after the order of the departmental proceedings?
After order.
After.
After order.
Was it placed before the appellate authority?
Yes, my lord. I have submitted.
this
Now, at
judgment-
that time, it was not passed.
Ah.
At that time, this order was not passed when I have filed the appellate authority. My lord, why I am saying so, that I have been honorably acquitted, my lord. Kindly one sentence, my lord, on the judgment, kindly say the last page. Thereafter, I will go to the main case, my lord. That is para 12, my lord. The prosecution has failed to stand its grounds and its stance has been dislodged from its very foundation. There is absolutely nothing in the evidence of prosecution witness to hold the accused person guilty for alleged offences. Therefore, my lord, why I am saying so, my lord, in Captain M. Paul Anthony case, my lord, the Honorable Supreme Court clearly says, my lord, regarding this, which I am going to refer, rely on the same, my lord.
This judgment was delivered when?
That is judgment delivered on 4/4/2024.
4/4.
Yes, my lord.
Yes.
My lord, these are the judgment of Honorable Supreme Court, my lord, that I am relying in this, my lord, kindly see. My lord, same sets of fact which is in the charge sheet, my lord. On this,
Did you approach the court to say that during the pendency, the departmental proceedings should not proceed?
No.
When they were criminal proceedings,
Yes, ma'am.
according to you, on the same facts,
yes,
did you approach the court saying that in view of the ratio of Paul Anthony, both the proceedings should not go? No, it did not.
no, at that time, it's not.
So therefore, the departmental proceeding went ahead.
That is departmental proceeding. that is 4/3/2021.
Hmm. That time the criminal matter was pending.
Criminal matter pending, my after department proceeding, my lord, the matter goes to the subsequently on the basis of the FIR matter goes to the criminal court, my lord, for adjudication.
Yes.
My lord, the fact of my case is completely covered by Paul Anthony case by Honorable Supreme Court and another
Paul Anthony was ex-party ordered.
expert order. Thereafter, my lord, it's a same sets of fact, my lord, also stated there in para 34 of the petition of the order, my lord. Secondly, I rely upon 2006 5 SCC 446 GM Tank versus State of Gujarat and others, my lord. So in this case also, para 30, my lord, relevant portion. May I read it, my lord?
Read the whole judgment.
Full judgment.
We'll start from para 3.
Yes, my lord, I am starting. The appellant joined in service in 1953 as an overseer. The applicant was regularly submitting in property returns showing all his movable and immovable properties. As per department, the movable and immovable properties were disproportionate to his known source of income. The Anti-Corruption Bureau carried out an investigation against the appellant and submitted a report. On the basis of the said report, a charge sheet dated 22/1979 was issued alleging that the appellant had illegally accumulated the excess income by way of gratification. The appellant submitted his explanation on 15/5/1979 and they denied the allegation as well as charge made in the charge sheet. A departmental inquiry was ordered, and as per department inquiry report dated 31/3/1980, the appellant was found guilty of the charge. The respondent, by order dated 21/10/1982, passed an order of dismissal from service as punishment. Against the said dismissal order, the appellant filed a petition before High Court. The learned single judge concluded that there is sufficient evidence against the appellant and dismissed the petition. Against the order of the learned single judge, the appellant preferred LPA and raised the relevant contention. The division bench dismissed the LPA by confirming the order of the learned single judge. The said decision is challenged in the appeal by special leave. The charges made against the appellant in the departmental inquiry are reported hereunder. The total income from wages, interest, house rent, insurance policy amount, street tank for the period from the year 1953 till June 1978 comes to so and so. Against that, total expense of street tank included expenses saving movable as well as immovable properties comes to so and so. Thus, an amount of rupees so and so has been found very much in excess than this known and legal source of income, and it appears the said amount has been earned by him through bribe, corruption, and illegal gratification, and therefore he is responsible liable for the breach of Rule 3(1) of the Gujarat Civil Service Conduct Rules 1971. Criminal case under the Prevention of Corruption Act. The Director Anti-Corruption Bureau had entrusted the inquiry to BP Rawal, Police Inspector, Anti-Corruption Bureau, Kutch at Bhuj. Mr. B.B. Rawal had inquired into the matter and submitted an inquiry report 8/9/1979. It showed that the total income of the accused out of his salary, interest, rent, and insurance policies, etc., from 1953 to June 1970 was so and so. On the other side, total expenditure, saving, and movable and immovable properties accused so and so. Thus, the amount to so and so was more than the known source of income of the accused, leading to the presumption that the amount was obtained by him by illegal corruption. Means, on the basis of the said report, his successor lodged the criminal complaint against the appellant in special case number 6/1987 before Special Judge Kutch, Bhuj, for the alleged offence punishable under Section 5(1)(e), read with Section 5(2) of the Prevention of Corruption Act 1947. The special judge had honorably acquitted the appellant of the offence punishable under Section 5(1)(e), read with Section 5(2) of the Act by holding that the prosecution has failed to prove the charges levelled against the appellant, and thus the appellant cannot be held to be guilty of the said offence. This acquittal is by way of complete exoneration and not by giving benefit of doubt, which is evident from the judgment of the special judge.
The division bench, however, overlooked this fact and additional fact that on the basis of very report submitted by B.B. Raval, the special judge had acquitted the appellant. It is also pertinent to notice that the respondent have not challenged the order passed by the special judge acquitting the appellant before any form, and thus that therefore the order passed by the special judge has reached its finality and has become final and conclusive. We heard Mr. L. Nageshwara Rao, learned senior counsel, assisted by Mr. Sanjay Kapoor, learned counsel, appearing for the appellant, and Mr. Maulik Nanavati, learned counsel, appearing for the respondent. We have been taken through the proceedings on the departmental procedure inquiry report submitted and the others order passed thereon, and also the proceeding initiated by the respondent before the special court under the provision of so and so of the said act. We have carefully read an order passed by the learned single judge in the writ petition and as affirmed by the learned division bench and the judgment passed by the learned special judge in the criminal proceeding. Mr. So-and-so appearing for the appellant made the following submission. According to him, the appellant, being a government servant, submitted his yearly property return regarding his movable immovable properties. This return for the year 1975 was verified by the department, and being of the view that the appellant had movable immovable properties worth more than the known source of his income, and being dissatisfied with the explanation of the appellant, the government requested the Director Anti-Corruption to inquire into the matter by its letter dated 1977, and on the basis of the report of investigation officer, the department had issued the charge sheet upon the appellant on the same material. Criminal proceedings were also initiated under section 51E of the PC Act, and charge being same on the same basis of the same charges and the same evidence, the department passed the order of dismissal on 21/10/1982, whereas the criminal court honorably acquitted the appellant by the order dated 30/1/2002. Learned senior counsel made the following submission, that there is no evidence to hold the appellant guilty or delinquent for the charges framed against him in the department inquiry, that the acquittal of the appellant in this special case is a relevant factor as the appellant has been acquitted on merits and the acquittal is clean and not based on the benefit of doubt or any technical proposition. The same evidence was laid in the department inquiry and therefore the dismissal order is bad in law. That the inquiry officer has given finding of fact in favor of the appellant, and despite the inquiry officer was found the appellant guilty of the charges. The additional fact was also brought to the notice of division bench that the special court has honorably acquitted the appellant in the same charge on 31/2002, but the bench has not considered the same. The division bench failed to note the difference between the exoneration and acquittal by giving benefit of doubt. It routinely held that the writ court does not reappreciate or re-examine the evidence laid before the inquiry officer, and unlike in criminal trial, the degree of proof in the domestic inquiry is restricted to preponderance of probability and not beyond the reasonable doubt. The LPA was accordingly dismissed and the order of the learned single judge was affirmed. Since the appellant has been exonerated of the charge, the appellant is entitled to reinstatement with full salary allowances and subsequent promotions. In support of his contention, Mr. L.N. Rao relied on the following judgment. Captain M. Palantoni, Union of India versus Singh, Corner Police, R.P. Kapoor, so and so. Mr. Maulik Nanavati, learned counsel appearing with the state, submitted that upon investigation, it was found that the total income of the appellant out of the salary, interest, rent, and could not be sufficient to acquire the property owned by the appellant, and that the total value of the movable and immovable other properties acquired by the appellant had been found more than the known source of income of the appellant. It was further contended that the appellant was prosecuted for the offence punishable under section 5(1)(e) of the and section 5(2) of the PC Act, and that the appellant came to be acquitted by the learned single judge, and that unlike in criminal trial, the degree of the proof in domestic inquiry is restricted to preponderance of probability and not beyond reasonable doubt, and that the acquittal in criminal trial on the charge of corruption under the PC Act ipso facto could not be projected as a weapon to undo the result of a validly held departmental inquiry. Arguing further, the learned counsel submitted that in the present case, the inquiry report is not casual, but well written, balanced, and making critical evaluation of all the evidence of the witness and documents. It cannot be said that the report is biased based on no evidence, and such a submission made by the learned senior counsel appearing for the appellant cannot be accepted when one gets into the reality of the factual profile so meticulously propounded in the inquiry report by the inquiry officer, which is based on the evidence and is rightly accepted by the disciplinary authority and justifiably affirmed by this learned single judge and again accepted the division bench. He therefore submitted that the acquittal in 2002 will have no bearing on the punishment imposed on her rules, and appeal on hand is totally meritless and deserves to be dismissed at the threshold. While concluding, he also submitted that the scope of the interference by the High Court is very limited and that the writ court does not reappreciate or re-examine the evidence laid before the inquiry officer for the simple reason that this court sitting and entertaining a petition under 226 of the Constitution of India is not an appellate authority. In support of his
So
contention,
please, what is the ratio?
my lord,
What is the ratio of the judgment?
17 years.
seven, 1, 2, 3, 4, my lord.
That where the witnesses and the materials are one and the same,
Hmm.
and the criminal court has acquitted on the same charges, departmental proceedings can sometimes be interfered with.
Maybe, my lord, but
Your
On-
case is that in your case also the charges are same.
same.
The witnesses were same,
Yes, my lord,
and the criminal court has given you an acquittal.
acquitted.
Therefore, departmental proceedings should be interfered with.
Yes, my lord.
Now come to page number 19 of the inquiry report. One nine,
1 minute. Yes, my lord.
you'll find the list of documents, list of witnesses.
Yes, my lord.
Then come to the judgment at page number 71.
Of which judgment, my lord?
The judgment you are relying on, judgment of the trial court.
Yes, my lord.
Come to page number 71.
It's a nice one.
Up to 68
Up to
page.
68, my lord, here in this picture.
In your affidavit,
Yes, my lord.
in the judgment, page number 4, internal page 4.
Oh, internal page 4. Points of determination, that page, my lord.
Before that, para 5.
Yes, my lord. During evidence, the prosecution examined informant as PW1 and other three witness PW1, PW3 and PW4 to prove its case.
So there are 3 or 4 witnesses examined.
Yes, my lord.
Now, from page, next page, para 10,
Yes, my lord.
para 9 and 10,
Yes,
the
my lord.
names of 2 witnesses are found.
2 witnesses are found, my lord.
There are 4 witnesses, but
Yes.
only names of 2 witnesses are found.
Yes.
If you come to the list of witnesses in page 19,
Yes, my lord.
only 1 witness is similar, serial number 9.
Yes, my lord. But as per inquiry report, my lord, two's name are my lord, confirm the two, and that is plaintiff number 3, PW1 and
Where is PW1 in the inquiry report?
yes, my lord, I'm showing. That is page 32 of the writ petition, page 32 kindly see, my lord. Statement-
32.
Yes. The statement of Miss Valnal Swamilani, victim.
So there are as many as 9, 10 or 11 witnesses
Yes, my lord.
in the departmental proceedings.
Yes, my lord.
Out of which only 1 witness is common.
My lord, if I am not wrong, my lord, 2 witnesses are common, my lord.
Uh,
That is
We don't know who are the witnesses in in the Sessions Court judgment. The list of witnesses is not here.
My lord, I have
Have you
noted-
enclosed?
my lord, two witnesses are connected, my lord, two witnesses. This is
In the page number 11, it is there.
Krishna Mohan Singh, my lord.
Hmm.
One,
Krishna
one,
Mohan.
Krishna Mohan, PW three.
Hmm.
He was in DP hearing, my lord.
Okay.
Krishna Mohan Singh. That is page 30, my lord.
Hmm. What is the name of the petitioner?
Uttam Kumar.
Uttam Kumar.
You declined to cross-examine the victim.
Yes.
My lord,
She was also examined in the inquiry.
at that time, my lord, their position there, my lord,
You don't know. How many petitioners are here? One or two?
one, my lord, item 7 is similar. Six. Reported the other two, three, their friends are there, my lord, they have been reinstated.
Mr. Chutia will need the records.
Record, my lord, yes, record is necessary. So her statement is very serious. She have confessed it. She has, my lord, stated that was raped. Very heinous crime.
There is a 164 statement also.
Yes. So far, he says it was Malad voluntary case. Voluntary case is a simultaneous prosecution.
Hmm?
One prosecution and departmental proceedings simultaneously cannot be run. That is his case. But the Ajit Dag case, my lord, I will obtain next time, my lord.
No. There is no law which says it simultaneously cannot run.
Can be.
But
If there is any, my
yes.
lord,
He has
any-
placed reference to Paul Anthony and GM Tang
yes.
to say that where the finding of the criminal case has given an acquittal, if there are same findings.
So Ajit Dag says, my lord, Ajit Dag case says by acquittal of the appellant by judicial magistrate,
Hmm.
therefore does not ipso facto absolve him from the liability under disciplinary jurisdiction of the authority. So acquittal by a criminal court, the dismissal order cannot be passed. I will produce it, my lord, later on. If there is a, my lord, serious facts and evidence involved, then my lord simultaneously cannot go it.
See, in GM Tang,
And then,
in Paul Anthony, it was ex parte.
yes.
He was dismissed ex parte. He did not participate. In GM Tang, the witnesses' documents were exactly the same.
Same.
In your case,
Only
only
two
three,
witnesses.
two
are
or
found.
three witnesses.
Yes, my lord.
Amount is same.
But discussing in the GM Tang, my lord, another case reference is page that is para 23, my lord.
Hmm.
Here also says, my lord, 23, if the trial of the criminal charge results in conviction and disciplinary proceedings are bound to follow against the public servant so convicted, even in case of acquittal proceeding may follow where the acquittal is other than honorable. This also goes in my favor, my lord.
Defense, there is no defense witnesses in the session court. So if there is no defense witnesses, how the prosecution will cross-examine, my lord, to bring out the facts? One of the facts, my lord. There is no defense witnesses. Only prosecution of the witnesses are there. Only on the basis of that, my lord, came to the conclusion by the district session judge that they have failed to, my lord, establish this case. Had it been, my lord, defense witnesses, definitely there will be cross-examined. That was not there. Nil.
But she refused to recognize the accused persons.
He denies. Yes, accused denies too, but adduced
No,
evidence.
the victim.
A victim,
During the trial did not recognize the accused person.
because two different persons, she says two different persons, my lord, that may be, my lord, in pretext of, I don't know, my lord, maybe there.
What is her statement in the records?
Records are not written, my lord.
You need the records.
I will obtain it. my lord.
Heard counsel for parties. This matter challenging the dismissal of the writ petitioner pursuant to orders passed by the disciplinary authority on the basis of an inquiry proceedings undertaken and which came to be confirmed in the appellate by the appellate authority. The inquiry records would be necessary for failure of the court. When can you get it?
Minimum 2 weeks, my lord. Today is, my lord, 18. Thereafter, my lord, close after vacation, my lord.
Let the matter be listed on
No.
4th of December.
4th of December.
On 4th of December.
Oh, no, direct.
Yes?
Yes,
4th December.
4th of December.
December 2nd.
Item 8.
Obliged, my lord. May it please your lordship. In this case, your lordship, I am dismissed from service. Lordship may kindly peruse the order. 31, 32, page number 31. I was terminated from service, your lordship.
The records are available here.
Records are not there.
This is pursuant to an inquiry.
Yes, inquiry report has
Get the
not.
records.
Right.
Without the records, how
Well-
do we decide?
But the only, if I, lordship may kindly submit.
After hearing it at some length, and you tell us the records are not available. Yes.
In this case, your lordship, the person is about to retire. He is supposed to attain 60 years of age. So there
This is not a case of dismissal.
It's a case of termination of service, your lordship. But then again, he will attain the age of-
When it is otherwise age of superannuation,
maybe next month, your lordship.
next month. Appeal, what is the stage of the appeal?
The appeal was dismissed, your lordship. It was not considered.
Can you get it by Thursday?
Mine,
Thursday?
I'll try my.
Does this matter on Thursday? Again, enabling the learned council representing the, which department is it?
Small industries.
Assam Small
Assam Small
Assam
Industries.
Small Industries Development Corporation Limited.
Assam Small Industries Development Corporation. Place the records of the departmental proceedings initiated against the expedition. Where is the appellate order?
Next one,
Appellate order is not.
not an next one.
Right?
It was not provided to me, your lordship.
Not provided.
No, appellate, I have been told that the appeal was not considered, but that particular order was not provided to me, your lordship.
Must be there in the records.
Yes, sir.
But can it be on Monday, man?
It can be. Why?
Tuesday, man.
Huh?
Tuesday, man. I'll have to confirm, man, whether the records would be readily available or not.
You confirm on Thursday.
Yes, sir.
Month.
Hello.
I think I.
I'm required to address your lordship on the maintainability of the writ petition before this court instead of the armed force tribunal. My lord, your lordship will kindly see Assam that tribunals section 14,
Armed Forces.
yes. It has been
Yes.
registered. Did,
Yes.
My lord, subsection 1, save as otherwise expressly provided in this act, the tribunal shall exercise on and from the appointed date all the service, all the jurisdiction powers and authority exercisable immediately before that day by all courts except the Supreme Court or the High Court exercising jurisdiction under 226 of the in the relation to service matter. Now, subsection 2, my lord, subject to the other provisions of this act, a person aggrieved by an order pertaining to any service matter may make an application to the tribunal in such form and accompanied by such documents or other evidence and on payment of such fee as may be prescribed. So any service. Then thereafter your lordship will kindly note any service and come to 30.
Hmm.
30, my lord. Service matters. Lordship got it, man.
3.
O. Service matters in relation to the
There
persons.
is no O here.
O is the 3O, man. Section 3O.
Oh, 3O. Okay.
Your lordship got it.
Service matters relating to so and so.
Relating to service matters in relation to the person subject to the Army Act, so and so, remuneration, pensions and other benefits, tenure including commissions of.
Appointment.
First is, my lord, service matter in relation to the person subject to the Army Act.
Hmm.
This Army Act, your lordship, will come, section 2 of the Army Act. Then I will go provide judgment.
Section 2.
2.
Yes.
Following persons shall be subject to this act wherever they may namely be, my lord, persons enrolled under this act. So it will be applicable to only persons who are enrolled under the act. Now for
No. No, there are others. Defining it comes
Yes.
down. Persons holding commissions, persons appointed.
yeah, others are there, but
Uh.
one of the things is that one has to be enrolled, and persons belonging to the Indian Reserve Forces, persons belonging to the Supplementary Reserve Forces, all these things are there, but one of the condition is one has to be enrolled.
No, it includes I also.
EFGH, persons not otherwise subject to military law who on active service in camp on the march or at any frontier post specified by the central government by notification in this behalf are employed by or are in the service of or are followers of or any portion of regular army. This doesn't include persons who seeks to get appointment under compulsory appointment. I'll give 2 judgments.
No, compassionate appointment where?
Compulsory appointment in the Ministry of Home Affairs, in the army, in the defense principal, in the defense act.
No, your father was
He was a driver,
in the army.
So
he died in harness.
he died, not he died, my lord. He was medically, my lord,
Discharge.
discharged. So for that matter, factually, I'll come to your lordship, page 64.
No.
But I thought I'll place one judgment in this regard.
No, we'll have to understand
The facts.
what is your claim?
Wait, my lord, your lordship will kindly see that his father was discharged on page 18.
1-8.
1-8.
Yes.
Discharge and my lord, post decompress skull defect. Last below, my lord, 25.
Now, where is your application for compassionate?
I'll come, my lord. Your lordship will kindly give me one moment. And page 17. Diagnosis remark is post decompress SIVC crematory skull defect. Then thereafter, my lord, my petition was dismissed at page 64. Page 64. As per existing policy contained in so and so Government of India, scheme for compulsory appointment act under the central government is applicable to the dependents of those armed forces, persons who died in the harness, medically invalidated out where competent medical authority considered disability as unit for suitable civil employment. On scrutiny of the medical documents of your husband, the competent medical authority has endorsed fit for civil employment, and employment assistance on compassionate appointment, the ground is not applicable to the defendants of the disease. This is the ground they have shown. Now, my lord, your lordship will kindly see page 27. I'll just take to your lordship page 27. This is the PPO page 27, he was discharged, my lord, right hand column, extreme right hand column, but above, my lord, above 3, my lord.
Hmm.
Your lordship must have noticed, my lord, medically unfit for further service. So what they have written, then page 32, your lordship will kindly see the scheme.
32.
32, this is the
Yes.
scheme, my lord. Scheme
Ah.
for compassionate appointment under central government. Object is this, timeline
So
is not a,
where is your application?
my application is under welcome. This application was rejected, therefore I came.
No, where is that application?
That is at page 63. ma'am.
So you have applied to the army.
Yes, ma'am. Prayer for appointment on compulsion ground, this was rejected.
So essentially you are asking an appointment in the army.
Yes. on
So if
compulsion.
it is an
That-
appointment
That
in-
scheme is there because of the scheme.
Maybe, but then it amounts to, you'll fall under the appointment.
No,
Uh,
yeah, enrollment, one has to be under the employment, rather
No,
that I'm,
under the Armed Forces Tribunal, section 3O
Yes, ma'am.
defines the service matters.
yes.
So in relation to army, it will include appointment.
Yes, ma'am.
PO, my lord, service matter means subject to the Army Act.
That's
Subject to the Army Act means, my lord, that again one has to be
But you
enrolled.
have applied to the army only.
My lord,
Your application is directed to the army.
Army,
You are asking for a job in the army only.
job only Army.
So
But-
it becomes an appointment under the army.
No, but these things will, my lord, it will come to a High Court because, my lord, Armed Force Tribunal, they cannot act on it because he is not a, my lord, enrolled person. I'll give one judgment, my lord, you also can take. Two judgments. This will make it clear. Where to do, C to do. My lord, your lordship will kindly see, okay, what it will be B to do. I'll go from the. This was the tribunal's order. B, B to do, yeah. First reason. This is the paragraph 1. Paragraph 1 and 5, your lordship. Assam, that Armed Forces Tribunal held that this is compassionate appointment. It cannot be in the tribunal. And this was upheld by the full bench of the tribunal. May I read that paragraph 5? Paragraph 1 is, my lord, direct the respondents to urgently consider the applicant's case for appointment, employment on compulsion ground. Your lordship may leave that. Paragraph 5. The paragraph 5 I'll read, my lord. On the contrary, relying on a single bench judge of the Rajasthan High Court and affirmed by the division bench on so-and-so special grounds, it was argued on behalf of the applicant that the definition of service matters appearing in section 3O of the AFT Act is wide enough to bring within its amplitude all matters pertaining to appointments and recruitments to the armed forces. The issue was discussed in detail in the case in Kaptan case, and it has been held that the AFT Act and the definitions of service matters appearing therein will only apply to those who are subject to the Army Act, Navy Act, and the Air Force Act, and an individual who is seeking appointment to Air Forces is not subject to the Army Act, Navy Act, and the Air Force Act, and the AFT Act does not give jurisdictions of this to this tribunal to examine disputes pertaining to recruitments and appointments to the Air Force service. Even though I.S. Singh, learned counsel for the applicant, tried to argue that by virtue of section 2.2 of the AFT Act, in so far as it relates to their service matters, the defendants, heirs, and successors of the retired persons subject to the Army Act, Navy Act and the Air Force Act are entitled to invoke the jurisdiction of this tribunal. The definitions of service matters appearing in section 2O of the AFT Act and the words appointments and enrollments appearing therein, including compassionate appointment, has been dealt with in details by us in Kaptan Singh, wherein the issue has been decided against the applicants, holding that all appointments, including compassionate appointments, are beyond the jurisdiction of this tribunal. Now, Kaptan to different, Kaptan to full bench. There is a full bench tribunals. Move to full.
Which is referred here.
Yes. See, my lord, your lordship will kindly see paragraph 32 and 34.
Paragraph.
32. Viewed does, may I read, man? Viewed does. This is reflected in that other case, my lord. Should I read?
We'll come back at 2.
My lord. The full bench judgment, your lordship, I'll take the lordship to paragraph 34. That will do the.
Yes. No, we get your point.
Yes.
Essentially, what you're saying is not yet employed.
Not yet employed. That is also there in Allahabad High Court judgment. I'm giving my lord 2015 SSC online.
Right.
There also, my lord, because of the held ground, he was not selected. So ultimately, court said paragraph 18. Same.
So now have the pleadings been exchanged?
Yes. Now, my lord, what I find, my lord, from that page 64, they should reconsider it. It has to be reconsidered because it is wrong.
Yes.
That page 64 by which they have denied the appointment on compulsion ground, that is wrong in a sense because they said, your lordship will kindly see page 32. This is the scheme of appointment to whom applicable is applicable to a government servant, to a department, dies while in service, is retired on medical ground. Immediately, this person has been retired on medical ground under Rule 2 of the CCS examination rules or the corresponding provisions of the sentence before attaining the age of 55. He retired on medical grounds. So he has been retired on medical grounds and also page
No, I think
37.
you fall under page 33 B, clause BC.
C is medically boarded out and is unfit for civil employment.
Yes.
And also 37, my lord, page 37. So they will have to reconsider that. Time limit for considering application for compassionate appointment, 10. Now, that beginning, my lord, the last sentence. Appointment is to be considered without any time limit and decision taken on merit in each case. Then 10, that is in para 9. 9 and 10 is Ministry Department can consider request for compassionate appointment even where
What is the ground on which they rejected it?
they ground that page 64 that
He is fit for civil
fit for civil employment. Where is that, my lord? He has been
Malad-
retired on, my lord, medical ground.
64 is your application.
No, 64 is, my lord, that impugn order. Application is at page 63. He is unfit for civil employment. The document shows, my lord,
Where is the Government of India Ministry of Personnel OM number so and so 9th of October?
that is when subsequently that is 98. Subsequently, this OM has been that this is what is there.
That is in
Page
76, my lord.
32.
Page number 76,
Page
serial number
32 is
change.
22. Page 76.
76 সেইটো বেচিছতে আমি হেৰি কৰিছো
Therefore, my humble submission, my lord, this matter should be remitted back to the authorities on the ground that their cancellation order doesn't hold because of the documents I have shown that he has been retired on medical ground. And if one is retired on medical ground, he is liable to be considered. The TP order itself says that because of the reasons. TP order
This OM that you're referring to,
Yes,
page number 64, there is an OM referred to,
yes, my lord.
98.
98.
98, my lord.
This also finds mentioned in page 46.
Please. Yes, ma'am.
What is the effect of that?
My lord, kindly in there, they are relying on that OM, my lord, that is page 33. Here also, my lord, this is the clause B, my lord, page 33. Of a member of the armed force who dies during, this is not related to us, is killed. Number C is related to us, is medically boarded out or is unfit for civil employment. Here in this case, my lord, he is fit for civil employment. And there is a doctor endorsement as in page number 64, my lord. Kindly come to.
He's in civil, he's a driver, man.
Page number 64.
Hmm.
In number 3, my lord, paragraph number 3. On scrutiny of the medical document of our husband, the competent medical authority has endorsed fit for the civil employment.
Oh, then fit for civil employment means outside army.
Outside army, yes, my lord. After retirement, my lord, he is fit for civil employment. And their OM, they rely upon that OM that is also, this is one of the clause, my lord. Is medically boarded out and is unfit for civil employment. That means if he is fit, then it is not,
Where is the medical certificate?
my lord, that is not here, my lord. I have to produce that certificate, my lord.
No, there is something you. What is that page number?
Page 27.
What is 27?
27.
Medically unfit for further service. Office of the PPO order, my lord.
This is PP order, not medical.
Yes.
Where is the medical certificate?
Medical certificate is not there, but this is at the time of his page 17, my lord. Hospital discharge slip, diagnosis remark, post, serial 25, post decompress SIBC, cremectomy skull defect. And this is he was not able to walk. As your lordship got it below, man, left hand side.
Page number?
Page 20, page 17, madam. Type copy of the relevant portion, my lord, the photocopy there at page 18. I have given the type copy. Type copy is more visible. Serial number 25. Diagnosis remark, post decompress crematory skull defect, and below, my lord, discharge summary so and so old, he was not able to walk. Now they are saying he's fit for civil service. On the face of it, my lord, this impugn order is
Are they allowed to
without any
produce
application
the
of mine.
medical
Other day, she
document
took
related
time
to
on the
medical,
ground
madam?
that this is not maintainable.
And
Today, she has not said anything about this certificate. Otherwise, why, if somebody is, he was a driver, he is not, he's a mountaineer in the armed forces. On the face of it, it's a non-application of mine.
regarding
It can-
maintenance,
Nobody can be discharged on medical ground on the ground that he is fit for civil service. If he is civil service, if he is fit for civil service, he is also fit for the army service also because he is a driver. This is the discharge certificate, that page 17 I have read. What else medical
Produce
certificate?
it day after.
Day after no, man, 1 week, man, because they said to produce from the Kolkata, because medical was done in Kolkata, my lord, Commandant Hospital, Kolkata.
Photocopy they will produce, man.
Yes, ma'am.
Produce the.
Then Wednesday, my lord. Because today is, Friday, like, no, Monday or Tuesday, my lord, Wednesday, any day.
27th.
27, yes.
27?
Lordship has heard, madam.
Yes, yes,
Yes.
but Mr. B D Das counsel very party. Senior counsel for the petitioner assisted by Mr. B. Baxter and Ms. E. Gail, learned CPC for the respondents. The petitioner is agreed that his case for compassionate appointment by the army of rejected. So petitioner's father is still alive.
No, he died.
Petitioner's late father was serving in the
20.
Indian Army as a driver and pursuant to an accident. He suffered an accident.
Yes.
He was medically discharged.
My lord, initially driver, then promoted to Subedar at army.
Where he was initially working as a driver and subsequently promoted to Subedar. And was because of injuries suffered during an accident.
No, he was fallen ill. Man.
He fallen ill. Because of his ill health, petitioner was medically boarded out of the services. So, pursuant thereto, the petitioner being the son, is the son, right?
Son.
Right for compassionate appointment, which came to be rejected by the order dated 16th of July 2021 on the ground that the late father of the petitioner, although medically boarded out, was considered fit for civil employment and therefore is not, therefore the case of the petitioner for compassionate appointment has been rejected in terms of the OM number 14014/6/94-ESTP stock within bracket capital D bracket close dated 9/10/1998, which is also reproduced in which condition is also available in the subsequent OM dated 2/8/2022. So, being agreed, the present writ petition has been filed. The respondents had initially raised the objection with regard to the maintainability of the writ petition on the ground that the writ petition is not maintainable as it relates to a service matter of the armed forces, and therefore the appropriate forum is the Armed Forces Tribunal. Mr. Das, Senior Counsel, has strenuously urged before the court that this objection does not have any merit inasmuch as the petitioner is not yet in the employment of the armed forces, and therefore the rejection of his case for compassionate consideration for compassionate appointment cannot be treated to be a matter pertaining to appointment under the armed forces or of the army, and thereby non-suiting the petitioner in the present proceedings by the writ court and relegating the petitioner to be to the Armed Forces Tribunal. The Ladakh Senior Council has referred to the judgments rendered by the Allahabad High Court, as also the judgments of the Armed Forces Tribunal, Principal Bench, Delhi, wherein it was held that it is only in respect of matters pertaining to it is only in matters pertaining to employment when the litigant is already in the service of the armed forces, that the Armed Forces Tribunal will have jurisdiction to decide a matter. Stop where the litigant is not employed under the armed forces. The Armed Forces Tribunal does not have jurisdiction to entertain such petitions. But Mr. Das further urged that the petitioner's late father was boarded out of the army on medical grounds, and the ailment suffered by the petitioner would not have permitted the petitioner's late father to opt for civil employment. Stop. Under such circumstances, it is submitted that the rejection of the claim of compassionate appointment by the petitioner is arbitrary, and the same should therefore be interfered with and set aside. MS Gayan, on the other hand, craves leave of the court to produce the relevant medical certificates. Stop has agreed to medical certificate of the late father of the petitioner, has agreed to let this matter be listed again on 28th. November.
Your Lordship has recorded everything, only one sentence, if your Lordship, it will complete my submission, that this scheme is applicable to persons who is medically boarded. This is what the scheme is all
Okay.
about.
The council or submission provided, this scheme is applicable only to persons who are medically boarded out. They are
Diploma.
27. We are listing it on 27.
Yes.
Yes.
Six step two items supplementary list item 53.
Here, we want the records. Who's for the state? Records. This is a matter challenging the findings of the disciplinary authority.
Personal over, na? But I will have to check it, but record.
You have to call for the records. It was
No, but
produced
that-
at a time, but subsequently taken back.
Oh, that's why, but I will have to check it, but the file is not with me, my lord.
We'll keep it on 28th.
28th.
Inform us.
I will check it, my lord.
You check up and let us know. Because the records will have to be perused. This on 28th of November. Mr. T.C. Sutia, Learned Senior Government Advocate, will obtain the records pertaining to the disciplinary proceedings of the writ petition, please it be copied.
My name is recorded. I'm for account, easy man.
Mr. S.K. Medi appears for account as well.
Item 10.
Please, your lordship. Lordship, it is in fact the second time the petitioner is before this honorable court. The petitioner participated in the selection process and got selected as an Anganwadi worker for Raghunandanpur Anganwadi Center, your lordship. Thereafter, there was an application from the union, Helpers Union, Anganwadi Helpers Union, to that effect that one person needs to be promoted. And as such, my appointment was held up, though all other persons who were appointed so the same list were given appointment letters. Thereafter, I inquired and came to know that the person for whose promotion the union was vouching was overaged. We submitted an representation and thereafter nothing was done. So we approached this honorable court previously. This honorable court, vide the order which is annexed at Annexure 8 at page 838, directed me to submit a fresh representation because the previous one was filed on behalf of the petitioner by her husband. So a fresh representation from within 10 days, and that was directed to be considered within next 2 months. I have filed the representation, your lordship. Thereafter, nothing was done. The petitioner did not file a contempt case because it was against the director, your lordship, the highest post. And I was just applying for Anganwadi worker. Thereafter, nothing was done, and I have filed the instant writ petition. They have filed their affidavit, your lordship. The affidavit starts from page 43. I'll just take your lordship to one paragraph, your lordship. At page 50, in fact, from page 49, in para 14, they have admitted that I have approached with a fresh representation. Thereafter, in para 15, it is filed by the CDPO. An evasive statement that she was not, at that point of time, she was not appointed as working as the CDPO, as such, she has no personal knowledge about it. Thereafter, in para 17, your lordship, para 17 will be important. That with regards to the statements made in para 22 of the writ petition, the deponent begs to reiterate the statements made herein above and further begs to state that as on date, the respondent number 4 has nothing to do for the appointment of the petitioner as Anganwadi worker of 6 number Poob Raghunandanpur Anganwadi Center because she has not received any direction or communication from the higher authority till date. This was the stand of the CDPO. Thereafter, I filed an additional affidavit, your lordship, wherein I have annexed a document as Annexure 10 at page 56, which shows the CDPO concerned was directed to submit a report to check the age, because I have disputed the age of that person who was sought to be promoted. She was overaged. So the CDPO was directed to file a report after within 7 days in that letter. But when I inquired with the director office, they said they're still awaiting this report from the CDPO. And the CDPO says that I have no direction for appointment from the higher authorities. And my appointment is still kept pending, your lordship.
Where is the development of the CDPO?
The CDPO in paragraph 17, your lordship, as I have read in page 50. The affidavit is filed by the CDPO.
Lordship, selection was made on 2019, Lordship. As per our affidavit, Lordship, it is stated that it was kept in pending, Lordship, due to some petition was filed by the all unit of Boitamari unit of Assam State Anganwadi Workers and Helpers Union, Lordship. That's why that post was pending, Lordship. Lordship, in this apartment, Lordship, he has not made a party neither Rebadas nor state unit or unit of Boitamari unit of the Assam State Anganwadi Workers and Helpers, Lordship. They have categorically stated in para 12 of this writ petition, Lordship.
What is there, para 12?
Of the writ petition, Lordship. Kindly pay this, Lordship. May I read, Lordship?
That with regard to the states that on getting the information from the office of the CDPO Boitamari, the petitioner learned that the Boitamari unit of Assam State Anganwadi Workers and Helpers Union had placed a request to the CDPO Boitamari to consider the name of Srimati Reba Das, an Anganwadi helper of number 7 Pub Raghunandanpur for the vacant post of Anganwadi worker at 6 number Raghunandanpur Anganwadi Center, Lordship. He has not made a party, and neither Reba Das nor Lordship and the state unit of Anganwadi Workers and Helpers Union, Lordship.
No, but if the CDPO has no instructions received for appointment of that person,
Lordship.
then what is to
The
be done?
CDPO has stated, no, Lordship, the deponent has stated present, there is no any intimation for the fresh appointment, Lordship. In regards to the fresh appointment, Lordship. Kindly see the,
Now, the prayer of the petitioner is to consider her case
Lordship.
for appointment.
Is not possible, Lordship. That was, union has filed a petition, Lordship, before the CDPO, Lordship. That's why that process was kept pending, Lordship.
No, why has the union, what has the union got to do with it?
So, that in our affidavit in opposition, kindly
But merely because somebody raises an objection, will you stop your
Lordship.
the administrative duties?
He has not challenged that order, Lordship.
What order?
Lordship, he has, that the union has filed a petition, Lordship, before this authority, Lordship.
No, union has filed. What has the authority done? Have they passed an order?
Authority has kept pending in this.
Therefore, the petition, why have you kept pending it? Why have you kept it pending? Either you you pass some order on the application, or you go ahead with the appointment. Why have you been sitting over it?
Then that representation can dispose that.
Why that representation is not filed by the petitioner?
That was pending before this. They have stated that one representation is pending.
Representation by whom? By the petitioner.
The petitioner also one representation is pending.
Where is that statement?
Which is at annexure. After this order of this honorable court in the previous writ petition, I have filed a representation that is at page 41, annexure 9. Because this honorable court, by this order dated 22/8, asked me to file a fresh representation, raising all my grievances.
That representation may dispose of, Lordship.
The mere disposal, there's a direction of the court.
And in pursuance to in furtherance of my representation, this letter was also issued, which I brought in through this additional affidavit, page 56. Because the director says that I've sought for a report from the CDPO. And the CDPO has not sent any report till date.
Lordship, in 28/3/25 order, Lordship, it is stated that, Lordship, as per court order, Lordship. However, there is no statement in the WPC indicating as to whether the select list is still valid at the point of time. As such, the matter would be called for the further examination, Lordship. As per the order dated 28/3/25, Lordship. It is posted as, Lordship, for further consideration. For further examination, as per the.
In fact, there was a query at the motion stage whether this post has already been filled up by this honorable court. Because I did not make a statement in my writ petition whether this post was already vacant, but they in their affidavit have stated it is still vacant.
You get a report from the CDPO. What have they done?
Not, sir.
Yeah, failing which we are calling the CDPO in
Not, sir.
person.
Will obtain notes.
Third, Mr. B.J. Mukherjee, 11,000, Mr. V. Chakraborty, State Council. The petitioner is agreed that pursuant to in spite of orders passed by the competent authorities clearing the way for appointment of the petitioner for appointment as Anganwadi worker at number 6 Pub Raghunandanpur Anganwadi Center, Boitamari, under the ICDS project Boitamari. The petitioner has not been appointed by the respondent 4 on the ground that there is an application filed by the Anganwadi Workers Association
Not union, Lord.
Union of Boitamari. So, although an affidavit has been filed by the CDPO, being respondent number 4.
3, Lord. Sir.
Huh?
Respondent number 3 filed a affidavit, Lord. Sir.
No, 4.
Lord, sir.
Page number 43. CDPO.
CDP. Not 4, Lord. Sir. Sorry. Here is 3.
There is no clarity as to what steps have been taken by the respondent 4 towards the appointment of the petitioner. So under such circumstances, we direct the respondent 4, namely the CDPO Boitamari, to place before the court the steps taken by the state authority pursuant to the which order passed by the
Honorable,
department.
this High Court. The order dated
Pursuant to the
22/8/2022,
dated 22/8/2022, passed in WPC number
5378.
5378 of 2022. Let these instructions be placed before the court within 2 weeks, list again on 5th of December.
Lordship, anytime after 10th, your Lordship, 5th time.
Then let it go to January.
Lordship, prior to
Matter
5th,
be listed again on 7 January.
God bless, Lord. Sir.
Item 11.
Lordship, may I kindly peruse the order dated 26/5/2025.
Lordship, may I please, Lordship? And that Deputy Commissioner's report is not yet received, Lordship.
Please call for it.
Kindly grant 2 weeks' time.
Pursuant to the order dated 26/5/2025.
Appeal for respondent number 6.
No, not pursuant, in terms of so-and-so. Deputy Commissioner Tamulpur, namely respondent 5, was directed to conduct an inquiry and submit a report as to whether the petitioner or the private respondent, number 6, are residents of the local area in which the number 2 Koirabari Anganwadi Center is situated. Where MSS Borwa, learned government advocate, submits that the report is not yet available. She prays for further 2 weeks' time. Your Mr.
I'm A. Sharma on behalf of IAM.
S.
A. Sharma on behalf of IAM.
A. Somwa
Sab Sharma.
Sorma
Sharma.
appears on behalf of,
IAM.
no, for which respondent?
Respondent number 6.
Respondent number 6. Let this matter be listed again after 2 weeks. The respondents will ensure that the report is directed to be furnished by the Deputy Commissioner. Which district? Tamulpur.
Tamulpur.
Will be furnished and placed before the court. Mr.
A. Talukdar on behalf of AK.
Mr. A. Talukdar appears on behalf of PTC, representing PTC.
Lordship, the date may kindly be fixed.
5th December.
Lordship.
Item 12.
This is a matter, my lord, where the petitioner's pension was all of a sudden stopped, my lord. He was, my lord, initially given provisional pension pursuant to the orders by this court, my lord. And then, my lord, while he was getting the provisional pension, my lord, the final PPO order was also issued. But, my lord, due to not giving the royal and non-royal certificate, my lord, his final pension amount could not be finalized.
Who is to provide that?
My lord,
Who is to give that certificate?
the department, the concerned department, my lord, the respondent
Which
number,
department is it?
respondent number 4, my lord, it is the Additional Director General of Police, Border, my lord, ADGP, Border Department.
Yes, what do you say?
No, my lord, in the case of the petitioner, my lord, he was, my lord, engaged after, my lord, 2005. As per our office memorandum regarding pension, lordship finally see our affidavit, my lord, page 95, running page. Affidavit filed by the respondent number 4. Alexa A, page 95 possible.
Yes.
21st January 20, office memorandum, proportionate pension ex-servicemen to the ex-servicemen. Revisal of the cabinet decision held on the cabinet meeting held on so government of Assam. They are pleased to allow the proportionate pension and other admissible pensionary benefits to the ex-servicemen who had retired from police border organization under prevention of implementation foreigners. PIF scheme rendering more than 10 years but less than 20 years of service from the date of initial appointment. Under the said scheme, relaxation of Rule 31 of the Assam Service Pension Rules and 69 in operation of Rule 235 of the said rules. However, these benefits shall be effective with effect from 1/9/2015 as decided by the government. The provision is not applicable to those ex-servicemen who were appointed under PIF on or after 1/2/2005. They basically petitioner in 2000 agreement, he was appointed as a PIF, and 2003 he was terminated. And again, he moved his writ petition. Thereafter, he was again freshly re-engaged in 2006. That's why he is not applicable. That is the stand.
Where is the PPO?
Page 50, my lord. Where the department itself has mentioned my date of joining and date of retirement. PPO starts from page 47, my lord. Annexure 7. Page 50 is the relevant portion, my lord, where the date of joining and date of retirement has been mentioned by the department. This PPO is issued on the basis of the information provided by the department, my lord, by the Office of the Accountant General. Page 50, my lord, at serial number 5. Date of joining is mentioned at 12/9/2000 and date of retirement, my lord, 2020.
You have already issued, Mr.
So that is
Government Council.
uh,
This has not been withdrawn or cancelled.
No.
account officer, they have issued the pension, but he challenged our letter, my lord, page lordship 46. No, 67. And it's 11.
No, that is the letter which is a reply to our representation made on 14/7/2023. After 8 months, my lord, they replied.
You sign an agreement of contract service subject to yearly renewal, 12/9/2000. You had been discharged from his contractual service on 23rd October 2003 on violation of terms and conditions of the agreement. B, again, you have been engaged in agreement on contractual service on 29/6/2006, freshly, by the government letter dated 2011. Your service had been regularized from the date of appointment 2006 as your break in service is not an artificial break in nature. You retired from service 2020, but you had not been given benefits of proportional pension in accordance with the government office memorandum dated 21/1/2019 as your appointment of continuous service is considered from 2006, that is 1 to 2000, post 1 to 2005. On aggrieve, you have approached this honorable court by the writ petition number 2258/2020. You have been granted provisional pension in accordance with the initiative view placed in the interim order 5/4/2021 to 2/2055. A matter of the Sokotor so and so honorable court. As per interim order, his proportional pension was not prepared. Your service had been regularized from date of appointment of 2006. As your break in service is not artificial break in nature in this regard, you may refer the judgment of 17/6/2022 Honorable Guwahati High Court in the matter of Sokoto Dhaka so and so. Whereas Honorable High Court has considered your subsequent appointment on 29/6/2006 as fresh appointment. The 11th ballot, the 11th prize for quoted here ballot. In the instance case, the petitioner was discharged from service by the order dated 23rd October 2003 by invoking clause 13 of the letter of agreement by which he was appointed, and there is no challenge in the such discharge from the service by the petitioner. However, by letter of agreement, he was again appointed in the same post after being acquitted in the criminal proceeding. The reason for which he was earlier discharged upon perusal of the materials on record, it is discernible that the break in service of the petitioner from the date of discharge 2023 up to his subsequent appointment 2006 was not an artificial break in service, but it was a break as because he was discharged from the service in an earlier engagement. Thereafter, given a fresh appointment after the reason for his earlier discharge stood mitigated. That's why the government by notification dated 21/19 has directed that the proportionate pension of ex-servicemen employed in the Assam Police Border Organization is entitled for those who join on or before 1/2/2005. But in your case, Honorable Court has considered your subsequent appointment as a fresh appointment. So, but in view of I further directed that the decision for stoppage of your pension is taken in accordance with the relevant administrative order and outcome of your writ petition. That is the Impug's order. He challenged it. So, according to us, as per Honorable Court also, court by the order that said that his appointment, subsequent appointment is a fresh appointment. So, it is after 2005. 1st February 2005, and he was appointed 29 June 2006. There's a press appointment. He did not qualify.
Where is the benefit under what OM or what notification the benefit is granted?
That is, Lordship, kindly see is that is pursuant to the orders passed by the Supreme Court, page 38 and Annexure 5. There was a direction, my lord, that these border employees, my lord, the practice of annual termination and
Page.
my lord, page 38. 38.
Yes.
If, my lord, I may read from the first paragraph. Whereas the Honorable Supreme Court of India in Civil Appeal number 7922 of 2002, arising out of SLP number 17226, titled as Muhammad Abdul Qadir Nazar versus DGP Assam, passed the following order. The circular dated 17/3/1995 is quashed. The appellant shall not be subjected to annual termination and reappointments. The benefits of this order will be available to other similarly situated ad hoc border staff, even if they have not approached the court for relief. In view of the above, the interlocutory applications for impleading are disposed of as having become infructuous. This order will not, however, come in the way of ad hoc employees working as a border staff being subject to any periodical medical examination or service review to assess their fitness and suitability for continuation. Thereafter, my lord, whereas the implementation of the direction of the Honorable Supreme Court will have a far-reaching financial policy and implication, the views of judicial, pension, and public grievances and finance departments were sought on the issue. Then my lord, I am skipping this part, my lord, coming to page 40, wherein the final decision was made after consultation with various departments. Page 40, my lord, paragraph 2. All the ex-servicemen appointed under the additional PIO scheme will get the benefit of time scale of pay with effect from the date of their initial appointment. Their pay shall be fixed at the minimum of the pay scale on the date of initial appointment. Thereafter, annual increment shall be granted as admissible. They shall be treated as employees against temporary post co-terminus with the additional PIO scheme of Government of India. And my lord, at paragraph 5, ex-servicemen would also be entitled to pension against their service in civil employment subject to completion of qualifying service as per Rule 176 of the Assam Service Pension Rules 1969. So, my lord, in the earlier writ petition, my lord, the prayer was, my lord, that initially, my lord, the petitioner was appointed in the year 2000. Thereafter, my lord, due to some pendency of a criminal case, my lord, he was terminated from the service. Thereafter, my lord, after his honorable acquittal in the criminal case, my lord, he was reinstated by the department. So our prayer in the initial writ petition,
But
which,
he have
which has
left it
been
around
pointed out,
page,
my lord,
sorry, my lord, page 40, paragraph 5. He has not completed it, my lord. Lordship, kindly see
yes,
page
however,
40.
those who are
The
appointed,
ex-servicemen would also be entitled to pension against their services in civil employment, subject to completion of qualifying service, as per Rule so and so Assam Pension Rules 1969. However, those who are appointed on or after 1/2/2005, their cases shall not be governed by the Assam Pension Rule 1969,
petitioner was
but they
appointed,
will
my
be
lord,
governed by the new defined Constitution Pension Rule 2009. That is why this office memorandum issued by the government, issue of this Supreme Court's order. Those who were appointed after 1/5/2005 or 1 February 2005, because he was freshly
Petitioner was
newly
not
appointed
appointed.
from 6. His appointment cannot be taken into from the 2000.
No.
Because he was discharged from the service, dismissed from the service.
Petitioner was, my lord, appointed in the year 2000.
2000,
And my
yes,
lord,
my lord,
page
he was
30,
terminated.
let me submit. Page 30, my lord, is the order of reinstatement. Page 30, if I may read, my lord. Discharged Chakra Deka so and so, my lord, is hereby reinstated in contractual service and posted to City of Guwahati. He would not be paid by thing for the intervening period of his discharge.
According to you, there is a continuous service.
No, that in the earlier writ petition, my lord, we have prayed that it is an artificial break in terms of the Honorable Supreme Court order.
That was rejected.
That was rejected.
You
Now,
did
my
not
lord,
appeal.
yes. So that particular period, my lord, was treated as dies known by the department. Meaning thereby, my lord, I will not be entitled to any arrears for that.
Not even your case.
No,
Your
lord.
case is that you are entitled to pension by virtue of the fact that it should be treated as a continuous service.
Yes, my
That's
lord.
your case.
That is my case, my
That
lord.
has been rejected by this court earlier.
No, my lord, that is, that direction was only not to, my lord,
Page 45, my
Three-
lord, this order.
that
Four-
was in respect of, my lord, the prayer which I have made, my lord, in the earlier writ petition.
Come to page 44, paragraph
No, lord.
4.
Yes. The petition is disputed for two purposes. Firstly, the petitioner claims
First was, my lord, to claim that the break in service between the date of discharge and his subsequent appointment was an artificial break and accordingly relied upon the pronouncement of the Supreme Court judgment in Muhammad Abdul Qadir
You
versus,
don't remember what you filed.
my lord.
Have you
No.
not gone through this order?
Yes, yes.
Then why are you
My lord,
reading
the
it again?
direction, if I may
You
humbly
should
submit,
be able to point it out to us.
yes. My lord, that was in a different context, my lord. That writ petition was filed praying for, my lord, I will just, in the affidavit in reply which I have filed, I have quoted the prayer, my lord will take
Your
page.
prayer is irrelevant. We are
My lord.
going through a judgment of the court
My
on
lord.
a petition filed by you.
Yes.
If you are aggrieved, you go in appeal, file a review. Otherwise, this order has to be accepted.
My lord, that
Whatever prayer
the
you may have made,
circumstances, yes,
whatever prayer you may have made in your writ petition,
my lord.
ultimately it gets answered in an order of the court. If you think that this order is not accurate,
My lord, in my
Or-
humble submission, my lord, that order was passed in a different context.
whatever context.
That
it was,
was,
but
that is why, my lord, I am
me.
pointing out the prayers, my lord. That
No, no, you
was, that was our writ petition, my lord.
Read para 7.
Yes.
Read para 7, there's a clear finding.
And 6 also, my lord.
Para 7, my lord, yes. My lord, that prayer was, my lord, only to treat the gap in service as an artificial break.
That was rejected.
Yes.
Uh.
But that does not mean, my lord, that the honorable court has directed to treat the date of my appointment to be from the subsequent date.
What else does it mean?
My lord, paragraph 7 of page 45,
Uh.
if my lord will see the finding of the honorable court.
The only part that was allowed is the benefit of the order or the order dated 23/9/2011. That's the only benefit given to you.
That is the pensionary benefits, yes.
Not pensionary benefits,
No, no.
increments.
Increments, yes. My lord, paragraph 7, if I may read, my lord, from such point of view, we are unable to accept the claim of the petitioner that he be deemed to be in continuous service without any break, and to accept the break due to be discharged in service to be an artificial break. But that does not mean, my lord, that my date of appointment
You are
changes.
trying to now interpret this order. You want an interpretation of this order.
No, my lord.
Then
My lord, what I am trying to humbly submit is, even if this break in service is not taken into consideration, my date of joining does not change, my lord. My date of joining
your date of joining
will remain.
for you to get a pension as per the rules, there must be continuous service.
Continuous service, yes.
My
You
lord.
had joined, there was a break in service.
My lord.
This, the court has held that it is not an artificial break.
Yes.
Yes, so there are two compartments.
My lord. My lord.
You're now the compartment for which you are asking for pension is the second one.
Well, the purpose of making the prayer that it is an artificial break was
That
to
has
get
been
the
rejected.
pay benefits, my lord,
No,
that there should be
that has been
continuity.
rejected.
That has been rejected, my lord. But for grant of pension, my lord, this minus this service, my lord, I am having more than 10 years of service. If the gap period is, my lord, not taken into consideration, even then I have more than 10 years of service. And moreover, my lord, this period has been declared to be treated as dies non by the department, my lord, meaning thereby, my lord, that they have the services are continued minus the, my lord, arrear benefits. That is filed by in their affidavit itself, my lord, they have stated in the earlier affidavit which they have filed.
Where is your appointment order, subsequent appointment order?
Subsequent approval of 2006.
My lord, that is the order, my lord, which I have read, page.
Is continuous service from
Page
2000
30,
to
my lord.
2003
Page
comes to
30.
an end.
Page
30, my lord.
30.
That uses the word reinstatement, my lord, and intervening period will not be paid. And even
Under what provision are you claiming pension?
under rule 176, my lord, of the Assam pension rules, my lord, in terms the 176, my lord.
But you are in contract service.
No, my lord, now that was regularized. That was subsequent to this, my lord, page 27. From the date of joining, my lord, all the experiments were given time scale of pay. My lord, page 27, 22nd July 2022. It is in communication, my lord, to the DIGP. if I may read, my lord. With in paragraph 1, my lord, in terms of the judgment of the Honorable Supreme
Where
Court.
is the judgment? What does it say?
My lord, it has prohibited with the practice of annual termination and renewal, my lord, keeping in view of the fact that these border employees are performing this service. My lord,
You are employed as what?
I was ex-service.
Official employment?
I was ex-serviceman, my lord. I have retired from the
Ex-serviceman.
Indian Army.
You did not earn any pension there.
I am earning, my lord.
Then
And but in this service also, my lord, there is a provision for pension subsequent to the order of the Supreme Court. The order of the governor, which I have just now read, my lord, 23/9/2011, that has provided that they are entitled to two pensions.
where is that order of the governor?
Page 38, my lord.
This is with regard to grant of time scale.
Thereafter, my lord, next page.
Hmm.
My lord, in the next page. Detailed discussion is there, my lord, regarding the pension.
What is the first line on page 39? Please read.
I am reading not pension and public I am reading from the last page. Not pension and public grievance department by their endorsement dated 49/2011 advised that Home Department may consider fixation of pay of re-employed ex-servicemen on their appointment in civil department as they will be appointed after getting military pension at the initial stage of the pay scale in pay band proposed to allow them. Thereafter, my lord, if the pensioner concerned acquire qualifying service in civil employment for pensionary benefits, this case shall be governed under Rule 176 of the Assam Pension.
How have you obtained the qualifying service?
10 years, my lord, my date of joining is 2000. My lord, I have stated in my petition at paragraph number 12, my lord, page 16, paragraph 13. Total service, my lord, even if I exclude that period, my lord, it comes to 13 years, 9 months and 3 days.
From since 2000 to 2000 appointment was come to an end on 2003 when he was terminated. Again, 2006 he was appointed newly.
I am not in contractual service, my lord. After the Supreme Court judgment, all the border employees, they are regular.
No, all the
to be
border
treated
Supreme Court
as regular
says.
employees, my lord, with effect from date of joining, and all have been given time scale of pay from the date of joining.
Date of joining, that has been he break.
Not fixed pay, my lord.
And page
as it was
39, however, the next paragraph, however, those who were appointed on or after 1/2/2005,
I'm not
their case
appointed one
cannot
after,
be.
I am appointed in the year 2000.
cases shall not be governed by the Assam Civil Service Rule 69, but they will governed by the new defined contribution pension rule 2009. How he can claim but that he was appointed in 2000? 2000, yes, he was appointed, but he was terminated service. And that was break is not an artificial break. He was discharged. He is admitted, my lord. Our High Court has passed this order.
regularized by treating it as
No.
dies non,
That cannot be.
and no arrears was granted.
Cannot be continued. Our lordship, page 67.
No, but this coordinate bench has already come to a conclusion,
No, that is only in respect of artificial break.
right?
That means, my lord, I will not get continuity. The pay scale
Why did you approach the court earlier?
for, my lord,
Where
the
is the
pay benefits, my lord, the
Where
pay
is the writ-
benefits.
Where is the writ petition?
Page
No, my lord, we take
42, my
page
lord.
104 of 104 of my affidavit in reply.
The
So
fourth-
where is that?
42.
I have quoted the prayer, my lord, entire prayer portion I have quoted.
104.
104. That was in respect of pay scale, benefits relating to, my lord, financial benefits. Page 104, paragraph 5.
Prayer number 3.
Prayer to,
Prayer 3.
yes.
So counting total number of years of qualifying service.
Yes. Yes, my lord.
What was the finding of the court?
Also,
So that, my lord,
page
there was
44.
no finding, my lord,
If there is
because
no finding, you file a review or go and appeal.
Yes, it did not, it has come to one of.
not even if that period is, my lord,
This is a prayer. It is possible
No, my lord.
that you may not have pressed
my lord,
it.
my humble submission is, my lord, even if that period is not taken into consideration, my date of joining doesn't get changed, my lord.
You have just pointed out your prayers.
Yes.
This prayer number 3 is for the number of
For that
qualifying
period.
service.
For that
determining your pensionary benefits.
Yes. I am not claiming that benefit. Even that period is excluded, my lord, I am entitled.
Huh.
My lord, even if that period is excluded, my lord, I am entitled because I have completed more than
That's what we are saying. Prayer
10 years
number
of
3,
service.
4 and 5. 3, 4 and 5.
Yes.
These are all relating to your pension. What was the finding of
But
the
by
court?
that time, my lord, my pension was already finalized, my lord. I was given PPO was also issued.
Hmm.
When I filed the writ petition, my lord will see the date of the PPO. Page 40. Page 50, page 51, my lord. 9/4/2021. Immediately after my retirement, I was getting provisional pension from the year 2020. I retired in the month of, my lord, March 2020. From April 2020, immediately department, my lord, started to give me provisional pension. And thereafter, my lord, on 9/4/21, my final pension was, PPO order was issued.
Due to oversight and erroneously that is issued. The
That oversight, my lord, they can deduct
that
those
is
3 years, my lord.
his case,
But
my
the
lord.
date of joining will not change.
No, but his case, my lord, page 42.
Date of joining, they have
it is-
admitted to be
he-
2000.
Against this order, he has not made any appeal or review. It has come to he attend the finality. Page 42.
That
and
already,
paragraph
already,
50.
my lord, they have
Let
given me
me
that
see.
benefit, my lord.
How he can say, my lord, he is continuing from 2000?
They have already given me that benefit, my lord, on 9/4/21. I have just read the PPO order, my lord. They have the
PPO
date of
order-
joining and the date of retirement. They have already condoned that period by issuing the PPO. The final order was passed on 17/6/22. This PPO was already issued, my lord, on 9/4/21.
Where is your appointment order, you said? Page 30.
The reinstatement order, my lord.
Hmm?
Page 30.
Yes, page 30.
Yes, my lord, Annexure 4. That is the order by which he was reinstated. And my lord, it was made clear that the intervening period of his discharge, earlier discharge, my lord, he will not be paid for that.
Alright,
And thereafter, my lord, they filed the affidavit in that writ petition.
now this order reflects that you are reinstated in contractual service.
Contextual.
Where have you been regularized after that?
Yes, my lord, this is an order of 2006, my lord. Thereafter, certain changes have gone into the nature of service. Page 27, which I have read, my lord. Page 27. Taking into account the Supreme Court's order, all the
Supreme Court's order is on a different, Supreme Court's order is on the artificial break.
Yes, yes.
That should not be given.
But certain other observations were made, my lord.
Hmm.
Taking into that consideration, policy decision was taken by the department. Page 27, my lord, which I have read.
Supreme Court order
In
also
terms
said,
of
but
the judgment
after
passed
one
by the page
First
27.
February 2005, those who are appointed, they will be not entitled. The Supreme Court
Page
order says,
27, my lord, in terms of the judgment passed by the Honorable Supreme Court, the ex-servicemen are to be treated as regular employees with the effect from date of joining. At that point of time, my lord, when my,
No, this is with regard to the artificial break.
no, my lord, pension benefit,
No, no,
all
no,
other
no, no,
benefits, my lord, next paragraph we'll
Supreme
see.
Court's view is that there are artificial breaks given. The single judge rejected it,
My lord,
saying that it should be regular employment unless it's for a particular scheme.
my lord,
That was upheld.
yes, my lord.
Now, in this context, your appointment is governed by the order at page 30.
Yes, my lord, one fact, that has now been deprecated, the practice here.
Replicated by what?
That practice of annual termination and renewal.
No, that annual termination is
Gone.
not applicable in your case because you are appointed after the termination.
No, my lord, my
Order
initial
says.
appointment is in the year 2000.
No, no. You see this discharge order?
My lord. It's
Discharge-
reinstated.
Discharge head constable so and so.
Yes,
Reinstated in contractual
With
service.
effect
So this
from-
is to be treated to be a fresh order.
no, but my lord, it further says it says reinstatement, my lord. And he says the intervening, the earlier discharge period, he will not be paid.
That's all right, but
Yes,
this order, has it been subsequently clarified to say that no, this is your regular employment, which gives you entitlement to pension?
thereafter, my lord, these developments
What
took place, my lord, wherein I have been regularized.
By
The-
which
all-
order?
The paragraph, page 27, my lord.
No, 27 order is not a regularization order.
No, that is the order, my lord. It
No,
says, my lord,
That is a
that
policy, assuming this is what you say it is.
They
It's a
have to be-
policy. There has to be subsequent orders for that. Individual orders.
my lord,
This is the policy. Let
Those-
us say we accept
my lord,
in toto whatever you have submitted.
my lord.
This is at best a policy.
No, my lord, all the ex-servicemen are, my lord, given. I have
Not like that.
that policy.
And then you have to answer the findings of the coordinate bench, which is against you.
No, that is only in respect of that period. My date of joining,
That period.
date of
if
joining
that
remains,
period is considered to be not artificial break. Then your primary submission that your service is regular because that artificial break has to be ignored.
no, that artificial break was only in respect to get the pay benefits, not for denying pensionary rights, my lord. Pension already, my lord, will see at page 9, already they have granted me, PPO was issued.
Maybe they have retracted it.
Already PPO was issued, my lord. My date of joining has been mentioned to be 2000. At the best, my lord, what mistake they have done, my lord.
Where is the order withdrawing it?
No order is there, my lord. They have suddenly stopped it. No reason was given to me.
no, reason is given.
No reason was given to me. I represented in the year 2023. After 10 months, my lord, they are replying.
67 page.
Yes, 67, my lord, we'll see. The representation was given on 14/7/23.
Reason
It's
is
a
there.
pension, my lord, pensionary rights, my lord. They were sitting over my representation for so many months. Nearly 7 months. And my lord, this talks about contractual service, whereas I am not in contractual service. All the regular border employees, my lord, their services are regularized.
No, they are on engagement on agreement, all contextual, not regular.
All the services are regularized.
No, no, regular. But this reason is given, Manor, in page 68. Government of Assam Memorandum number 21/1/2019 has directed that the proportionate pension for ex-servicemen employed in the Assam Border Police Organization is entitled for those who join on or before 1/2/2005. But in our case, Honorable Court has considered your subsequent appointment 29/6/2006 as fresh appointment. In view of the above, I further directed the state the decision of the stoppage of your pension is taken in accordance with the relevant.
Once my
administrative order.
services are regularized, my lord, it cannot
No,
be
no, no,
fresh
that is the
appointment.
Judicial finding.
No, my lord,
There is a judicial finding refusing your.
that is not only for that period, my lord. The date of joining is not directed to be taken as subsequently, my lord.
No, the government says that in terms.
That
in
period can
order
be
to give
ignored,
you
my
the-
lord.
In order to give you the benefit of the memorandum,
Yes.
your service, you are entitled to join honor before 1/2.
I have joined, my lord. My joining is 2000. Thereafter, the services were regularized. I have joined in the year 2000, my lord. What was earlier rejected by the court, my lord, only for that particular period, my lord, from the total qualifying service, my lord, that can be subtracted. That should be subtracted, my lord.
You read para 6 of the judgment.
Page 44.
In the instant case, yes, my lord. In the instant case, the petitioner was discharged from service by the order dated 23/10/2003 by invoking clause 13 of letter of agreement by which he was appointed, and there is no challenge to such discharge from service by the petitioner. However, by a later letter of agreement, he was appointed in the same post after being acquitted in the criminal proceeding, reason for which he was earlier discharged. Upon perusal of the materials on record, it is discernible that a break in service of the petitioner from the date of discharge on 23/10/2003 up to his subsequent appointment on 29/6/2006 was not an artificial break, but it was a break as because he was discharged from his service in his earlier engagement and thereafter given fresh appointment after the reason for his earlier discharge stood mitigated.
Then
So, my lord, only that period will be excluded. My lord, my date of joining doesn't change. And that was
The
not the.
finding of the court is very clear in para 6 and 7.
My lord, the prayer which I have read, my lord, it was
Your
my
prayer,
writ petition.
Whatever your prayer may be, but we go by what is the judicial order. If you want a clarification, you file a proper application. But it will not be possible for us in this jurisdiction to give a further clarification to a judgment. Court has absolutely held that your subsequent appointment is a fresh appointment.
yes.
How can you claim that your earlier appointment was prior, regularized? What kind of interpretation are you trying to give to these paragraphs 6 and 7?
No, that was only in respect of that break in service cannot be
This
treated
is
as
not clarified in the
continuous.
judgment, Mr. Counsel.
No, the court has not directed to, my lord,
Court-
treat
court-
the subsequent date as my date
No,
of
you
joining.
read para 6 and
My
7
date-
again
No.
and explain to us. My limited
No.
understanding of English, this is what exactly.
From
the
such
court has
point,
intended.
my lord, from such point of view, we are unable to accept the claim of the petitioner that he be deemed to be in continuous service without any break and to accept the break due to discharge in service to be an artificial break.
Clear, my lord.
That is the only prayer was, my lord, not to treat it as an artificial break. Whereas the affidavits file, my lord, clearly says they have treated the period to be dies non. No back wages, nothing will be given. The order of reinstatement,
You have not read the paragraph properly.
my lord.
We're dismissing it.
My lord will give me one more opportunity, I will.
To
come
read it again.
My lord.
Read the order again.
What remains, my lord? After our High Court has passed this order, the clarified this, he cannot interpret it, my lord.
Thursday.
Thursday, my lord.
Yes. Right. Mr. H. Gupta, counsel for the petitioner, Mr. T.C. Sutia, senior government advocate, MS for R.K. Talukdar for accountant generals. Matter be listed on Thursday for further hearing.
As a part of matter, my lord.
Further hearing.
Order.
There's the team.
No, I. He's coming, my lord, he's on the other side.
Who's your other side?
Iki Goswami. Let me start, my lord.
Readings are complete.
You think are complete.
This is the case for dismissal.
Not dismissal, my lord. This is a case for dismissal, but reinstate, subsequently reinstated as per Honorable High Court order to keep a lenient view. And the subsequent what happened? The appellant the appellant authority, respondent of 4, while reinstating, he reinstated him, but at the same time, the period of absence is they call calculated as no work, no pay. And for pension benefit is concerned, no dies now. So, all back pages.
Why is it required for admission hearing? Records are there.
Oh, the affidavit has been, detailed affidavit has been filed, Malo.
Huh.
What
One
is
of
it?
the-
And written affidavit.
Huh?
You failed with affidavit.
Their contention is that
So can it dispose, my lord, because
Disposed. Where is that order? Where is that order?
yes, sir. Page 95.
95.
94.
We can dispose it off by dismissing it. That will take 2 minutes.
Relevant part is 98, my lord, page.
आइए आ जाओ। कौन आई जाओ? पूछो मारा था। Resolution भूल के लिखनी है फिर
Who is?
मूड दुखों की वाली
কোনে কিন্তু আপনাদের আপনি এইটো আপনার
दूसरा बोलो लेकिन बोला स्पॉट काय को
পেজ মাত্র ভুল
Running page.
রানিং পেজ এটা আছে আর মোট ভরা
वो चीजें मन बोल सकते हैं स्वयं कम वो कैसा की फाइल करो This will require some hearing. Are you relying on any authorities?
Yes. That's something.
There is no automatic
Yes.
presumption that you are entitled.
Yes. For that, I think that. Oh, 2013. 2013.
We'll keep it for hearing then, heard. counsel for parties, pleadings have been exchanged. Matter therefore be listed for hearing. January,
December.
December,
December because party is also forwarding.
let it be in January,
Okay, my lord.
8th of January.
8th of January.
8th of January. Mr. U.K. Goswami for the learned CGC. The Reyes Mitra for the schools. Yes.
14.
My pleasure. This is the matter pertains to non-payment of retirement benefits, madam. And you see the page number 28. This is the intimation letter. The petitioner here off to retire on 39/2021. But the authority has intimated the petitioner on 4/11/2024.
Yes, then
Thereafter, I have filed representation before the authority to release the retirement benefits. There is gratuity, leave salary, and the GIS. Accordingly, the BTC authority has sanctioned, there is page number 31. Page number 31 is the DCRG. Page 33 is the leave salary. And thereafter, page number 34, that is GIS. That till today they have not been released the sanction amount.
yes.
Along with the NPS, the petitioner is governed by the new pension scheme. That is also not been released till today.
Yes.
Lordship, we need to obtain instructions. Instruction is awaited.
You filed an affidavit, someone has filed an affidavit.
Finance,
Finance has filed.
finance,
All right, third, Mr.
No, they are seeking repeatedly, my lord. The petition-
Your name?
A Boro, my lord.
A. Boro, learned counsel for the petitioner, and Mr.
A Talukdar on behalf of AK Bhuya, standing
Mr.
counsel.
Talukdar, appearing on behalf of Mr. A.K. Bhuya, standing counsel, Boroland Territorial Council, submits that the instructions are not complete. Mr. A. Chaliha, appearing for the Finance Department, the other end, submits that an affidavit has already been filed. Considering the issues raised, the Boroland Territorial Council is directed to apprise the court on the next date fixed as to why the claims of the writ petitioner has not been released. MS A. Sharma for Accountant General, S. Bora for
2 and 7.
1, 2, and 7. When can you get it?
Lordship, 2 weeks time. Lordship.
So don't just pray for 2 weeks as a matter of standard practice.
It's on 18/8/2025, same prayer, my lord, they have taken, my lord. And they said 18/8, my lord.
Get it on 8th of December.
Lordship,
8th of December,
8th of December.
my lord. My lord.
List on 8th of December.
highly of.
All right.
For hearing items 15 to 19.
Please, my lord. My lord, as directed, we have compiled a list of a chart of the cases wherein the medical supported medical documents and review medical guidelines are all it has been enumerated in the compilation for these 4 cases.
You have submitted.
My lord.
Yes.
The first item has been heard by my lord. I don't know if my lord has recorded, but this is in consonance with the earlier judgment and order passed by your lordship in WPC 5955 of 2024.
59.
Right.
Okay.
Yeah, respondents, what do you say? What is what is this
Tremors,
pectus excavatum?
oh, item number 15 is
Defective distant vision.
the distant
And
vision and
gross-
tremors present in both hand, Lordship.
Hmm.
We have filed our affidavit, Lordship. Petitioner was rejected on the ground of tremors and defective eyesight. Eyesight should be on 6.6 and petitioner is 6.9.
And what is the finding of, is there any finding by the civil medical authorities?
Three, my lord.
Huh?
One by the Assam, but one by the medically fit declared by state level recruitment board, Assam Police, that is at page 66. Then medical certificate of Kokrajhar Medical College, page 67 to 68. And medical certificate of the Guwahati Medical College at page 69 to 71. They all say that there's no deformity. It's normal.
The requirements are different in Assam Police, between Assam Police and central government, Lordship, CAPS, Lordship.
Tremors?
Here, tremors, when tremors present, then one cannot target it appropriately in
We know, but
Yes.
Tremors could be a hurdle for even Assam police. But the medical report reflects there is no tremor.
There is no tremor.
Yes, sir. Yes.
What was the direction given here in the earlier?
That is not,
Review medical.
Review medical and possibly with an expert of the relevant field. Because our prayer is also very limited, my lord. We cannot go beyond that.
In
We will
that-
seek another chance to present ourselves before the board. And if then, if things come to a naught, then we are gone.
Yes.
We don't have a case.
Give them a chance for review medical board in view of the two contradicting medical reports.
Here videography also there, Lordship.
Whatever is there,
Tremors are present, Lordship. Review medical, at the time of videography is there, Lordship.
For the tremor.
no, then you'll have to say that the civil medical authorities documents are incorrect.
What is the procedure they have taken? It was not their lordship. Because our procedure is laid down as per our guidelines, lordship. That the civil was not done as per our guidelines, lordship. That was our plea, lordship. The civil hospitals were done their own way. But our system, we have to take as per our guidelines. We have to videograph this. This was done as per videography. When both the tremors are availing, lordship, if we have some confusion on that, then we have to go for the appropriate route. Otherwise, lordship,
Where are the medical documents of the civil hospitals?
My lord, at for item number 1, item number 15, it is at page 67 and 68.
What we are asking you, where are the medical files? These are available in the hospital.
It's available in the hospital, my lord, and
You don't have any copies.
no, my lord, and in a review, if my lord allows the review medical examination, then the same shall be collected and produced before the. Because and not only one medical, these are independent government doctors. Now if they are wrong, then we have no case, my lord. So let us at least give us an opportunity to go and appear before the review medical board with a concerned specialist from the relevant field.
Already review has been conducted, Lordship, and reports are there,
But
Lordship.
review conducted without the specialist from,
If there is any doubt, it is clearly mentioned in our guideline, Lordship.
no, we know that, but tell us one thing, if there is a doubt, where does a candidate go? Where is the appellate authority? Where is a,
DME, at first DME has been conducted. When he was rejected in DME, after that he may apply for review medical board.
when
Then there is the opinion of review medical board is final, Lordship. That is in,
These same contentions were raised
in 5955, and my lord has considered that,
It
and
is not tremors, Lordship.
not tremor,
Not
but,
tremor.
but there are some deficiencies where
No, tremor or no tremor, what we want to say is that the civil law and hospital says there is no defect. Now it is possible that these, the procedure required to undertake the test was perhaps not followed by the civil hospital. We are not saying it was not, but it's possible that the procedure which what is the CRPF? BSF,
This is
staff selection
CRPF.
commission.
CRPF.
Review medical examination is done by CRPF, Lordship.
CRPF.
Different department has conducted, Lordship. We, the X-ray also with us, Lordship, and medical report also there, Lordship.
No, we direct you to conduct another one. Call for whatever records are there. You ask them to produce the relevant records. And you conduct it, videograph it, and pass an order. And make it a point to have a committee, a body comprising of civilian doctors, specialists.
Here, review medical is conducted by MBBS medicines doctor, medicine Lordship, and to diagnosis tremors, medicine specialist are there.
With tremor is medicine, okay, vision, all right. Ophthalmologist may not be necessary. Optometrist may be good enough. It's a different issue, but tremors, so you'll need a neurologist.
If required, Lordship, then they can go.
No.
Yes.
His claim is that there are no tremors. Your finding is that there are tremors.
Tremors, yes.
He says there are no tremors. Now, if you need to have a special medical specialist, then it has to be of that relevant subject.
If Lordship, the prima facie, but I have been instructed that if tremors are there, the hands are like this, Lordship, tremors are there, and it has been the videography. If it is there, Lordship, prima facie, we did not require the opinion of a.
Where is that videography?
Yeah.
We have.
You show it to Mr. Sharma, let him see how his client has performed in the videography.
Madam, the only concern is that in each of these cases, contradictory reports are from different medical.
That gives rise to a disputed question of fact.
That is what, my lord.
Which is why normally we would not like to enter.
My lord, but my lord, because
Unless-
we are jobless youths, so a chance may be given on the grounds of natural justice and
Jobless-
equity.
jobless.
That because after we go there, whatever happens, we are bound by that.
No, but you must also make an effort to make available the
My
medical
lord.
documents by which they have conducted the
Minor, but
test.
in medical colleges and OPD departments, this is not. If I go to a specialist and they referred me to another examination, only then I get this kind of.
No, but whether an OPD is sufficient to determine the case.
Yes,
of
minor,
tremor.
because the machinery, the doctor, a specialist has conducted my test and filed a report. A government doctor would never file any dubious report.
No, we are not even suggesting.
No, my lord, but without examination,
What
with
we
a
are
proper
saying is-
examination, a
What we
doctor
are
would.
saying is whether all the procedures required.
I'm sure it has, it
additionally
must
are
have been.
followed or not.
I'm sure it must have been.
This video is not opening, Lordship. I will bring the fresh one,
You
Lordship.
must be scared of Mr. Shah. We are sending it back, have a review medical board with the concerned specialists and give a report. We'll keep it pending. We'll not
Yes.
close it.
Yes.
We'll not close it. We'll keep it pending. Conduct a test and give it back to the court. The finding.
And what will happen, Lordship, is will become a precedent, Lordship, after review. That's why we are only. Otherwise, there is no problem to get them reviewed, Lordship. Otherwise, it will, because as per our guidelines, once review medical board has been constituted, thereafter there is no provision for further review, Lordship. Only our concern is this, Lordship.
My lordship may record it that it shall not be a precedent in other cases.
Where is the DME?
DME report as their lordship. We are proceed.
Page 64.
P 64.
To review. board.
This is review medical.
I told you.
Review medical.
Here is
The original is.
asset loss this fellow. Yes. Okay. Right. Here is
Here is the DME.
Now, review medical from the DME card is there, sir. The medical. DME. DME from our.
I should. Even the matter is so.
সিহঁতৰ লগত নাই, সিহঁতৰ লগত নাই। সিহঁতে অকল তাহাঁতৰ ঘৰৰ পৰাই আনিছে। এইটো কেকটাছ আছে।
I think we have expressed our views in this judgment.
Yes.
And this judgment clearly can cover all these matters pending. WPC 5955.
It's a connected repetition, my lord.
It was.
Into the more was it in accord?
It was.
We have permitted them to file an application along with whatever medical reports or whatever they have. The authority will call for their reports if they require. And thereafter, if they are satisfied, then the review medical board will hold and decide.
Jurisdiction, court jurisdiction or mental. Two matters may not be.
This was of lordship, there was a mental, one was mental case was there.
Mental instability was there, lordship.
No, in this chart, item number 31, 32.
No, this is today item number 15, 16, 17 and 18. This
Sorry.
four.
Yes, yes.
Oh.
15 to 19.
15 to 19, madam.
15 to 19.
Yes.
Is there any mental illness?
No.
No, is there no?
No, madam.
So we are disposing it of in the same line.
Pectus examination was also.
So there are others, the others are also there, 20.
21 also same.
Only.
You can
Pectus
take back the
extraction.
medical report.
8 to 10. By अपना नाम ना
15 to 19
15 to 19.
is disposed of
सकते।
in terms of WPC 5955.
और ये बेटा मिला
All right.
5 in terms of finding.
15 to 19 and 21. Pectus excavation. 27 to Pectus. No. 27 to Pectus.
And
And 27.
27. Who's for 27? That is also Pectus. 27.
21 to what?
21. 21, 15 to 19 and 21 and 27.
21 and 27. Who's for 27?
I am for 21.
Huh?
I am for 27.
No, 21?
My lord, I am.
Okay. All right.
Good idea. 23 to the left.
Then the other matters, make a chart, give it to us again. Prepare a chart like this, becomes easier to, instead of going through all the papers. The rest of the matters we'll keep it on for some other date, 27th maybe. 27 November.
27 November.
Number will be 40%, 15, 16, 17,
16, 17.
Next week.
Next
Lordship.
Who will take the responsibility of preparing a chart? Government?
Lordship. I will.
You prepare and give it to us and share them a copy. Share your emails so that the soft copy can be shared with. It will order it. Disposal. All right, disposal.
Obliged.
Item 20.
And 23.
So the rest of the matters we'll have it on 27th. Huh? 27. All right. Yes.
Item number 20.
Yes.
Lordship, my senior is on legs. Your Lordship will kindly take up this matter for some time.
Passed over. Mr. Das.
No, I can start it, but it will not be possible to complete today because it's a departmental proceeding and
Last occasion you had prayed for some time.
yes, that I have brought, my lord, because they disputed my SC status
Uh,
and those documents I have brought, my lord, lordship can have a look.
We'll fix a date then.
This, the chart book was to be produced in order.
Yes, I have got, my lord, in original, my lord. I can place, and I have got the reasons also why the discrepancies, my lord.
Let this matter be listed again. On 4th of December,
My lord, after fourth, some difficulty on fourth, 5th, some difficulty, my lord. I'll be out of station, my lord.
11th. 11 December? Yes.
Or 16, my lord,
16.
difficult. Then 9th, my lord. Actually, 11, my lord, port number 10 takes
All
up
right,
all the
9th.
high